rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome, everyone. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
Thank you, Madam Court Officer. Any change in the appearances, Ms. Alici?
Good morning, Your Honor. We have been joined today by Mr. Ryan Marr, legal intern.
Thank you.
Thank you.
Good morning, Your Honour.
Mr.
As Mr. Rees indicated, he's not present today, otherwise no changes.
Thank you. Mr. Cadman?
We're joined this morning by Mr. Buckley.
Thank you. We also note that Mr. Gucati and Mr. Haradinaj are present in the courtroom. Before we start with Mr. Reed, can the SPO indicate whether they object to the admissibility of the expert report? I mean, of course, the parts authorized by the Court of Appeals panel.
Your Honor, we don't object to the admission of the expert report. We would just like to clarify that in our understanding of the Court of Appeal decision are not admissible paragraph 26 in its entirety, paragraph 27, second period, paragraph 28 in its entirety, paragraph 30, last period, and paragraph 31, letter A, the words in accordance with the rule of procedure and evidence, and. Thank you.
All right. We'll get back to this at the end of the testimony. I believe that we are now ready for expert witness number 1253, Mr. Bob Reed. Can we have him online at this time, please? Good morning, Mr. Reed.
Good morning, Your Honor.
Can you hear us all okay?
Yeah, loud and clear, thank you.
Very good. We realize it's morning here and late afternoon where you are. We appreciate you. We appreciate you being with us. Under the circumstances, and we hope you're feeling all right.
Yes, I am, thank you. Yeah, much better, thank you.
We will start now with your testimony. You will see on your screen the text of the solemn declaration which you are asked to take pursuant to Rule 149, Paragraph 5 of the rules. Can you see it?
No, but I've got a copy of it here.
We better make sure we have this ability.
I know, it's there now.
It's there. Okay, thank you
Yeah.
very much. There might be a slight delay.
Okay. Conscious
So
of the
if you will please read it aloud. Thank you.
Yes. Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will perform my expert analysis conscientiously and to the best of my knowledge, and that I will state my findings and opinion accurately and completely.
Thank you. Mr. Reed, as you may know, we are hoping to hear your testimony between now and noon today, Hague time, and also, on if necessary, on Friday, the 28th of January, between 8 a.m. and noon, Hague time. These are, as I've earlier stated, afternoon and evening times at your end. Counsel for Mr. Haradinaj, Mr. Cadman, will go first in asking you questions. Once he is finished, the Gucati defense may have some questions for you. Then it will be the prosecution's turn to cross-examine you, and members of the panel might also ask you questions. The estimate of Mr. Cadman for the length of your examination was a half a day, and it may be shorter than that. The Gucati defense did not provide an estimate, but we hope that their questioning, if any, will be relatively short, and the SPO estimate is up to 4 hours. The panel may allow redirect examination if conditions for it are met. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them that you don't understand, and they will clarify. And I realize you've done this before, Mr. Reed, and these are known to you, but we want to make sure we go over the rules.
Certainly.
Speak clearly into the microphone, and also wait a few seconds before answering a question, and speak at a slow pace for the interpreters to catch up with you. And also, in the event one of the counsel needs to say something before you answer, there's ample time for them to do so. While you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony. If any person asks you questions about your testimony, please let us know. Please also base your answers on your experience and your expertise, and respond to questions within the limits set by this panel. Mr. Reed, over the weekend you received some additional material from Mr. Cadman, which we authorized to be disclosed to you in advance. You also received by now a list of documents the Haradinaj defense intends to use during your examination in chief. Just before the prosecution starts its cross-examination, you will also receive a list of documents they wish to use today. If their cross-examination continues into Friday, you might get a list of additional documents on that day. We might also have to take some short breaks to get the prosecution documents to you before the cross-examination starts.
Certainly.
We also take it that counsel for Mr. Haradinaj has informed you of the following. You are not allowed to give evidence in your examination in chief on any matter that goes beyond the scope of paragraphs 9 to 25, 27, 29, and 31 of your expert report. These are paragraphs indicated by the Court of Appeals as permissible for the purpose of you challenging the testimony of Ms. Pumper. The topics you covered in these paragraphs are, first of all, standing operating procedures and guidelines regarding the investigations, including search and seizure operations, chain of custody practices at the ICTY, authentication of materials, including a comparison with SPO practices, and an analysis of the SPO's 3 search and seizure operations at 8, 17, and 22 September 2020. You are authorized to testify on these matters for the purpose of challenging the testimony of Ms. Pumper. Notwithstanding the additional material you received, you are directed to answer questions with a view to explaining but not exceeding the analysis you provided in the aforementioned paragraphs of your report. You received a transcript that has a confidential segment. Any questions regarding that segment should focus on the procedures described therein in view of the analysis provided in your report, and should not reveal confidential information. This is the essence of the decision we rendered on Friday as regards to your anticipated evidence. Do you understand all of that?
I do, Your Honor. Thank you.
Mr. Cadman, the floor is yours.
Your Honour, before we start, I just wanted to inquire whether we're likely to be taking a break between now and 12, so that I can...
We will, in some hopes that we will finish with your testimony by the time of the break. I think you have re-estimated approximately 2 hours, is that correct?
Yes.
And if you can shorten that so the break comes earlier, that's fine too, but you go ahead.
And I just wanted to clarify that I'm not permitted to go through paragraphs 28 and 30 of Mr. Reed's report, because that wasn't my reading of the Court of Appeal decision.
28 and 30 are not to be, you're not to go into 28 and 30. They were crossed out and we gave that notice.
Before I begin, can I just ask that Mr. Reed's report is provided to him, that is DNH 0856 DNH 0868.
I have a copy of that, Mr. Cadman, in front of me, if I'm allowed to look at that.
Can I get you to look at the last page, which is DNH 0868, and confirm that's your signature?
That is my signature, correct?
And can I confirm that that report is dated and signed on the 9th of November 2021?
Correct.
And that no changes have been made to that report since that time?
That's correct.
Could I ask that Mr. Reed is shown the document at DNH 1307 to 1310? And that is the letter of instruction that you received for your expert evidence in this matter.
Yeah, I have a copy of that as well, if I may refer to it. Yes, that's correct.
Thank you. Can I ask you to look at the last page, which is 1310, in which there are 5 documents listed that you've been provided with that forms the basis of your report?
Yes, I'd got the 1, 3, 4, and 5, and I recently got the public redacted I got the public redacted declarations, number 2, just recently.
And that was going to be my next question, that you have the trial transcripts for when witness W04841, Ms. Stenka Pumper, gave evidence between the 18th and 26th of October, and as you have said, you have now received her declarations.
Yes, that's correct. And I've read those transcripts, the public transcripts.
And can I ask you to confirm that the contents of your report are true to the best of your knowledge or belief?
That's correct.
And it accurately reflects what you will say during your examination in chief today?
That's correct.
Now, the prosecution, Ms. Bellucci, has already indicated that there is no challenge to your qualifications as an expert, which I'm most grateful for the indication. But just for the record, I just have a couple of questions in relation to your professional background. Can I start by asking, what is your current occupation?
I'm retired now.
And what was the last role that you held?
The last role that I held was between October 2019 and September 2020. I went back to the IRMCT, the Mechanism for International Criminal Tribunals, and worked with Prosecutor Brammertz on the tracking of the Rwandan fugitives. There were 6 to 8 outstanding fugitives. And I worked with him on that. And when the arrest of Felician Kabuga was conducted, I went back into retirement in September 2020.
And what field do you specialise in?
Well, criminal investigation is my background. I'm a former New South Wales police officer. And from 1994 up until August of 2018, I worked at the ICTY and the Mechanism for International Criminal Tribunals. And the last position I held there was the Chief of Operations for Prosecutor Brammertz. And
we'll come back to your work at the ICTY in a moment, but prior to your appointment in 1994, what was your role in Australia?
I was a detective within the New South Wales Police Force. I was designated a detective in 1981, and I went immediately from my detectives course, or within a month or 2 of my detectives training course, to the homicide squad. I then was seconded to the federal body, the National Crime Authority, which was a new body set up to investigate organised crime. And then in 1987, I went to the Federal Attorney General's Department again on secondment, where we investigated persons who'd entered Australia, who it was alleged had been working as part of the Nazi regime during the Second World War. In 1991, I then went back to the New South Wales Police, to the Drug Enforcement Agency, and I stayed there until June 1994, when I left on leave without pay to go to the ICTY as an investigations team leader in the Office of the Prosecutor.
And were you one of the first investigators in 1994
Yes.
at those two?
Yes, that's correct.
And during that early phase, were there guidelines on standard operating procedures?
When I arrived, there was very little, but in the first few months, that was the focus of what we needed to do. We needed to set up the office as an office of the prosecutor. We needed to identify investigations that needed to be carried out. We needed to put in place standard operating procedures and guidelines in relation to the major areas that we would carry out our investigations, in addition to the recruitment, etc., that any new office has to undertake.
And during that phase, that early phase, did you become an investigations team leader?
I was recruited as an investigations team leader into the Office of the Prosecutor.
And was that in relation to a specific investigation, or was that a general appointment?
No, it was just a general appointment. And then when I arrived, we looked at the allegations that had been in the media with the Commission of Experts as to what investigations we would carry out. And my duty became, or one of my duties was to investigate the crimes that were allegedly occurring in the municipality of Prijedor, which is in northwestern Bosnia, where there were 3 alleged concentration camps there.
We'll come back to that in a moment, but
Sure.
during your during the entirety of your time, and I don't want you to answer this in particular detail, but were you familiar with a system at the ICTY at that time called Xylab?
Yes.
And just very briefly, could you explain what that is?
Xylab was our document collections all went through Xylab. It's a search engine, and there are discrete procedures that need to be done. We put together, initially it was a paper metadata information form. It then became an electronic form that gave you all the metadata in relation to each and every document that was going through. It also gave, you could also put into the metadata the author of the document, the classification of the document, whether it was confidential, whether it was restricted, what the document was, for example, witness statement of X. And then once that form was submitted, initially it was manual stamping of each and every document. Eventually it became electronic stamping, with the exception probably of handwritten documents, which was still manually done. And then once the stamping had been done, the document would be scanned. The optical character recognition would be run across it to make it searchable. And we worked closely with Xi because in the VCS language, they had diacritics, and it was very difficult to be able to pick up. So in the beginning, we used to use wildcards, an asterisk or a question mark, etc., so that they would pick up those names. Eventually, we were able to be able to do a full search across them. Then once the document was scanned, OCR'd, the document was then put into the evidence unit repository, and that was where it was stored. You know, as I said, the classifications are on it, whether it was a classified document, was confidential, whether it was restricted, and whether it was chain of custody.
And Just for the sake of clarity, you've mentioned a couple of acronyms. So when you do mention an acronym, which may not be commonly known, if you could just explain what that is. When you say BCS, you mean Bosnian, Croatian, Serbian?
Bosnian, Croatian, Serbian, yes.
And
of course, once the conflict in Kosovo in 1999, we also had the Albanian language as well that we used.
And that was an office-wide system?
Yes. For the Office of the Prosecutor, yes.
Yes. And was that a system that was restricted to access within the physical office in The Hague, or was that something that could be accessed remotely?
We couldn't access it remotely. I remember when we first went into Kosovo in June 1999, I think, we sent a mobile evidence unit team down to work with the documentation that we were seizing in Kosovo. And that team, they were based in Skopje in Macedonia. We would take the documents from Pristina or wherever we got the documents from, Peć or wherever it was. They would be transported down to Skopje, and then they would be processed along exactly the same lines and then taken back to The Hague.
So it's fair to say that if there was a field office, that process would initiate or be initiated within that field office rather than taking the material back to The Hague and inputting it into Xylab in The Hague.
The majority of the time it was put into Xylab in The Hague. That was the only exception. There may have been another exception, I can't recall, but I do vividly recollect that one because I was heavily involved in it, where we had a field office in Skopje, and we sent our evidence unit down together with mobile scanners, etc., to be able to process the documentation. But normally we would bring the documentation back to The Hague, whether we drove it back. If it was chain of custody, we would always drive it back. If it wasn't chain of custody, then it would come back that way, in a bag or something like that, in an airline flight.
And you just said, just so it's clear, that you sent the evidence team down to Skopje in order to carry out that function there.
Yes. We just didn't know how much documentation we were going to get. And if you recall, we had a fairly tight schedule on our hands because we'd already indicted President Milosevic and 4 or 5 of the Serbian government. So we wanted to get any documentation that was coming across from police stations or municipal buildings that had been evacuated by the Serbs. We wanted to get that documentation into the process immediately.
And just moving on to your experience as a witness, have you provided expert testimony previously?
Not so much expert testimony. I've given factual testimony. But in the beginning, when I gave evidence in relation to the cases in Prijedor, in particular the Duško Tadić trial, we did touch on the chain of custody of certain documents, etc. But not actually as an expert witness. I gave my testimony as a fact witness.
And when you were giving your expert testimony of a fact witness, what kind of fact evidence would you give?
Well, it'd be the interviewing of the witnesses. It was mainly in February, I think it was January, February 1996, we got the opportunity to go and do crime scenes examination of the area of Prijedor. We went into the Amaska camp, we went into the Keraton camp, we went into the Ternopolje camp. We did crime scene examinations, we did videos, we did photographs, etc., etc. So I was like tendering evidence in relation to those particular areas that we had investigated. We'd already issued the indictments in relation to those crime bases. And this was the first opportunity we'd had to go in and do the crime scene examination. So I was giving the evidence of what we had done when we went into Prijedor and how we collected the evidence, etc.
And so would you have given evidence on the search and seizure operations that were carried out as part of those operations?
Yeah, a couple of the search and seizures there. We seized documentation in 1996 from the camps. We had a search warrant issued by a judge of the ICTY. And then I think it was 1997, we went into Priador again with a search warrant issued by a judge of the ICTY. And we searched the municipal building, the police station, and I think the political headquarters of the SDS. And we took thousands and thousands of pages of documentation there. And that was treated as chain of custody. And it was taken from Priador back to Banja Luka, from Banja Luka to Zagreb, and then it was driven from Zagreb up to The Hague under chain of custody conditions.
I want to come to that in a bit more detail in a moment.
Sure.
And you've touched upon issues of chain of custody. So were you required to give evidence on the chain of custody procedures that were undertaken?
I don't recall actually giving the evidence of the chain of custody. No, I don't recall that.
And during your time at the ICTY, what teams and units were you in charge of?
Well, I was in charge of the investigative team that did the investigation in relation to Northwest Bosnia. That eventually broadened from Priador, and it broadened into the hierarchy of the Priador municipality. Then we went up another level to the what I call the Banja Luka, the regional level, and indictments were issued against the political leader and the military leader in Banja Luka. And then I also, I think in about 2000, maybe 1999, I also took control of a number of the support units, the evidence unit, the document video indexing unit, our searching unit, and the trial support unit.
Now, turning to paragraph 10 of your report, you use the phrase standard operating procedures and guidelines.
Yes.
What types of, we'll call them SOPG, were put in place at the ICTY with which you were familiar?
Well, the majority of the SOPGs that we put in place, I was very familiar with. Can I just go through, can I read from my report?
Yes, you may.
Thank you, Your Honour.
Just briefly. Do not read the entire report. Just read.
No. I mean, the types of guidelines and standard operating procedures that we put together were file management guidelines, how to put together a request for a field mission, search and seizure mission guidelines, opening of an investigation, taking of statements from victims, interviewing of suspects and accused, how to conduct the mission that you're going on, what to take on the particular mission, reporting conditions while you're on the mission, reports at the conclusion of the mission, acquittal of mission expenses, the gathering of evidence while you're in the field, how to register that evidence when you obtained that evidence and got it back to the office, search warrants, how to apply for a search warrant, what needed to go into the application for the search warrant, and similar things like that, and payment for out-of-pocket expenses to witnesses. And that was probably one of the last ones, because we found that when witnesses were travelling to us, they would have out-of-pocket expenses. And at that particular time, the UN had never heard of that type of thing. So we put together some guidelines so that the UN understood what we were doing.
And who defined those principles?
Well, the principles, they would have come at that particular time probably from the Deputy Prosecutor's office, because we didn't really have a prosecutor in place until about September, I don't think. So the Deputy Prosecutor would have been issuing the instructions. There was a Chief of Investigations at that particular time, and it would have been generated from the Chief of Investigations. I know I worked closely with the Chief of Investigations at that time to put together those particular standard operating procedures and guidelines. And
how were those guidelines disseminated amongst the staff of the Office of the Prosecutor?
Once they were put in place and the Deputy Prosecutor had signed off on them, we then brought into practice an induction course for all new members. And as you arrived in the office, whether you were a secretary, whether you were a senior investigator, a legal officer, or you worked in the child support unit, wherever, you were inducted. And certain members of the office would give lectures in relation to the standard operating procedures or the background to the conflict of the war. Some of the lawyers would give the legal proofs of the elements of the charges, the elements of the crimes, etc., etc. So we had an induction course, and that went up until around about, I think it was about 2000, that induction course was in place. And the new prosecutor who came in decided that it would be better to not so much have the induction course, but to put the new member into an experienced trial or investigation team, and they learn on the third. But we had an edited induction, and there was a booklet that they were given. Each new staff member had to come to the Chief of Investigations to say that they'd read that booklet and that they understood what, for instance, the rules of procedure and evidence were that related to the investigations, etc., etc. And that's how the people learnt their trade at the tribunal.
And as part of that induction program and the booklet that you've mentioned, would it set out the structure of the office so that staff within the office were aware of different units, like evidence custodians, disclosure officers?
Yes. Yes, I mean, one of the people that would give the lecture to the induction course was the head of the evidence unit, and what was expected of the staff member to work with the evidence unit, what was required, the forms that were required, how you had to set your evidence out and bring it to the evidence unit, etc.
Now, moving on to the search and seizure operations, were you involved yourself in the planning or carrying out of search and seizure operations?
The first two search and seizure operations we did was, the first one was in January, February of 1996. And I was the investigations team leader. We went in with a team. There were investigators, lawyers, and that was our crime scene examination, what I call our crime scene examination mission. We were armed with a search warrant issued by a judge, and we took thousands of pages from the camps, the different areas. We took photographs, and we just carried out basically a crime scene examination. And where there was documentation, we took that documentation and took it back to The Hague. The second search and seizure mission was much, much more complicated, because we had asked for the assistance of, I think they were IFOR at that stage, implementation, NATO implementation force. And they were the military. And we asked for the assistance to go in and do a search warrant in the municipality of Pred, or of the police station, of the municipal building and the SDS headquarters. Now, this was unheard of. And in some quarters of the military, they saw it as mission creep. But we were very, very lucky. The area that we wanted to do, the British forces were there, and they were very, very supportive, and they supported us fully. So armed with a search warrant from a judge in the tribunal, we carried out the search and seizure of those buildings. It was very, very closely coordinated with the military. We went in early morning. The military sent one of their advisors to the president of Republika Srpska, who was Mrs. Plavšić at the time. She knew about the search, and when I got to the police station with the chief of police, his phone was ringing, and Mrs. Plavšić said to assist the tribunal as much as they could. So that sort of lessened the anger a little bit. And then we just went out with the Republika Srpska police and the military as our security. We searched the various establishments. We took thousands and thousands. I can't remember exactly how many pages it was, but it was tens of thousands of pages from those establishments. And then the military were a bit concerned about the amount of time we were taking, so we went back to the military headquarters in Banja Luka, where we did the inventory. And as the inventory was finished the next morning, we took it back to the authorities in Prijedor. We left them a copy of the inventory. And then we drove the documentation in the evidence boxes back to the Zagreb field office. And from the Zagreb field office, the documents were then driven by an investigator and a driver from the office back to The Hague, where they were then processed along the scheme that I've just outlined earlier.
And that was carried out effectively just shortly after the end of the conflict?
December 1997, I think it was. The Prijedor was a particularly fragile area in Bosnia. In July of 1997, we'd issued a sealed indictment and against the mayor of Prijedor, the executive officer of Prijedor, and the chief of police. And unfortunately, in the attempt to arrest the chief of police, he was shot dead. So there was a lot of anger towards the tribunal, if I can put it that way. So, yeah.
So, in difficult circumstances, I want to ask you now about the planning prior to the mission that was carried out. What kind of planning was carried out?
Well, initially, we were, a legal officer and myself, we flew to Sarajevo to meet with the command of the military, the NATO military, and I'm sure they were still called the Implementation Force in those days. And we met with them. A lot of them were very hesitant, but eventually we were able to convince them that, look, this is, what we need to do. We're a court of law. And luckily, as I said, we had the British, and the British were able to assist us greatly. And they agreed. And once they agreed, then the mission could start to be planned. We then went to the same legal officer. I then went to Banja Luka, where the British military were based, and we met with the commander and his deputy, outlined exactly what we wanted to do. So once we had agreement as to a rough date as to when we wanted to do it, we went back. We planned our side of things from the ICTY, and the military planned their side of things. And then we went back again a week before the date we were due to do the mission. And it all came together. Our teams came in. There was a big team that came in because we had to cover 3 buildings. There's a team leader for each building. I think I did the police station. I did the municipal building. One of the other team leaders did the police station. Another team leader did the SVS headquarters, the political party headquarters. There was exhibit officers allocated. We had all the forms. We had exhibit forms, inventory forms, etc., etc. So yeah, it was a fairly detailed mission that we had to go on. Yeah.
And in the carrying out of that mission, was that carried out in accordance with the SOPG that were in place at that time?
Yes, I mean we refined it probably after that. To include, other amendments like, working with the military, what you've got to supply to the military, et cetera, et cetera. And then short time after that, I think in March 1998, we did the military barracks in Banja Luka. That was done by another team leader, but I went on that mission, but as support.
And in your experience and in your professional opinion, why is it important to have SOPGs for missions of this kind?
So you have uniformity right across the office, that everybody carries out their duties in exactly the same way. I mean, it's not just a search and seizure mission. It's everything right across the office. Your file management systems, your evidence unit, processing. If everybody's on the same page, and the only way you can get people on the same page is by having a standard operating procedure or a guideline in place to be able to do that. Particularly when the office gets to the size that our office got to. I mean, in the early days we were very small and you could communicate it. But once you got an office of, when we were working in Kosovo, our office was up to 800 or 900 staff with seconded staff as well, exhumation staff and things like that. So when you have a large office like that, it's important to have those sorts of things in place.
And on a mission of this kind, where you said that there was a big team, would you have ensured that all members of that team were familiar with the SOPG?
Yes, definitely. Before we left The Hague, the teams were briefed as to what we wanted to do. And then the night before we went in, we had a full briefing with the military. I briefed both the ICTY staff and the military staff as to exactly what was happening.
And your instruction to carry out that mission, how would you have received those instructions?
Well, I think it was a team decision that we made. I think we saw it that we had a number of people that had been indicted and that were in custody, and we needed a lot more documentary evidence. So the team, and I'm pretty sure we would have gone to the prosecutor as a team, to the prosecutor and the deputy prosecutor, and said, "This is what we want to do," and we got the sign off. Normally, the deputy prosecutor was the person who was the operational person, if I can put it that way. The prosecutor knew everything that was going on, but the deputy prosecutor was more at the level of the operation level. So he would have signed off on it and given us the approval to go and meet with the military in Sarajevo, to meet with the military in Banja Luka, et cetera,
So prior to embarking on the mission, you would have had a team meeting with members of your team. You may have even been briefed by the deputy prosecutor prior to embarking on that mission.
Yeah, he may have been at the briefings. I can't recall now. But he was very hands-on as a deputy prosecutor.
I want to move now to the practices and procedures related to chain of custody. And for ease of reference, I'm referring to paragraph 13 of your report. Now, what steps were taken, in your view, to comply with practices and procedures relating to chain of custody?
The chain of custody is pretty basic and simple, is that the minute the document comes into your possession, you must know where it is 24 hours a day, 7 days a week, even when it's in your evidence unit. And that's basically what we did when we went on our mission to Prijedor. We had an evidence officer who, when a document was, or when a group of documents perhaps was taken out, he would then record. Now, he wouldn't record every single page of every single document that came out, but he would say a binder labeled XYZ, and then he would ensure that binder went into a evidence bag or to an evidence box, which would be numbered, and then he would record that number on his inventory sheet. And then once we'd finished our searches, we took all those documents back. We were able to say exactly which box or which bag each and every document was in. And then if needed to be, we would then do a more detailed inventory to be able to be taken back to the Prijedor authorities. And the reason we took everything back to the Prijedor authorities was so that they knew what we had taken and they agreed with what we had taken and they signed for it and said, yes, we agree that you've taken all that. And we did the same thing in Banja Luka when we went to the 1st Krajina Corps, the military barracks in Banja Luka. And in some instances, we didn't give them the documents back, but we burned a DVD for things such as soldiers' files, and they were needed for pension rights and things like that. So we would then burn a DVD and send that back to them so that they could do that. But we kept the original documentation. And we made sure that at every stage of the process, we knew exactly where that document was every minute of every day. And even when it gets back to the evidence unit, there was a process there for recording the chain of custody. So that in some instances, and if I can give an example, in the Milosevic trial, the presiding judge in the Milosevic trial ordered that the original documents had to be tendered in evidence. Some of the other trial chambers said, no, a copy is sufficient. The presiding judge in the Milosevic trial wanted the originals. So you will probably see, or you will see, in the evidence unit, if it's chain of custody, if it's come from, say, Banja Luka, or it's come from Srebrenica, wherever it's come from the search and seizure mission, you will see exactly where that document is. The ERN number 1 to 4 is exhibit P7 in the Milosevic trial. Or the document has been taken by investigator so-and-so to the Netherlands Forensic Institute for handwriting analysis or for blood sampling or whatever. So you know where the documentation is all the time.
And at paragraph 14 and 15, you give these two examples, one from December 97 in Prijedor, and then you give the other example at paragraph 15 in relation to Banja Luka. Now, just dealing with the first example that you gave, just talk us through briefly, if you can, specifically what chain of custody was followed in that case?
Well, exactly what I've said is that the search team, you would divide your team up. You would have a search team, you would have an exhibit officer, you would have a photographer and or a videographer, and it was the exhibit officer's duty to ensure that every single document that was being taken was recorded and was placed into either an evidence bag or into an evidence box. Now, I can't recall now whether we were using evidence bags. I do know that when we got back to Zagreb, we had boxes, but there could have been that the evidence bags were put into the boxes. So the evidence custodian or the evidence officer would record what was being taken, and then we would seal everything up, and we then took it back to the military headquarters at Banja Luka, where they were unsealed again, and we went through the specific documents then to say, okay, what exactly have we got? And I know it was a huge process that we went through, and the interpreters and they were up all night going through all the documentation so that we could do a fairly detailed inventory. Again, not page by page, but to give the authorities a general idea of what we had taken and then once that was done and that was delivered to the authorities in Prijedor, everything was sealed again, and it was driven with military security to Zagreb, to our Zagreb field office, where again it was put into a locked room, and that room was also sealed overnight. And I'm pretty sure, although I can't be 100% certain, that one of the security guards from the Zagreb field office stayed in the office that night to guard that documentation. And then the next morning, one of the investigations team leaders and the driver from the Zagreb field office, they drove from Zagreb to The Hague, where the documentation was then handed over under chain of custody to the evidence unit. That I'm pretty sure it was the head of the evidence unit was handed over to, and then they processed the evidence from that time on.
And just a couple of points on that. So you said that there would have been an exhibits officer, and correct me if that's not exactly what you said, but my understanding was that you said that there was an exhibits officer who would have accompanied the team on the seizure.
Yeah, each of the teams had an exhibit officer. Like for the police station, there was an investigations team leader, searchers, a photographer, videographer, and an exhibits officer for the police station, for the municipal building where I was, and for the SDS headquarters.
And when dealing with the various different stages of the chain of custody, would those individuals have been required to give a statement at any stage on the basis of what they had carried out?
I don't think they gave like a statement. They may have given, they may have put together an official note. I really can't remember now. But we knew who the exhibit officers were, because each of the exhibit officers would sign, as they'd finish each page, they'd sign. So I suppose, yes, that technically is a statement. They've signed at the bottom of the inventory form that they have taken custody of this documentation.
And you said earlier that certainly in relation to the Prijedor situation was that you would have done the inventory on the scene. If not, it would have been taken to another location where the inventory is done, but taken back to the Prijedor authorities to get them to verify what was taken.
Yes. Yes, we always did that. We always wanted them, whether it was, the Serbs, whether it was the Muslims, whoever it was, the Croats, it didn't matter. We always took the inventory back so that they knew exactly what we had taken. In fact, that's how Republika Srpska knew that we had a lot of the staff records from the first Krajina Corps, because they asked us, could they please have those records back, because they needed it for pension entitlements of the soldiers, and we burned a CD and sent it back. So that's how they knew we had those type of records.
And they would have confirmed the inventory against the documents seized?
They wouldn't have gone through each and every document, But there was always, when we did the search, particularly at Priador, we had a Republika Srpska police officer with us. And he was also seeing, or she, I think there was a couple of ladies as well. They were seeing what we were taking as well. And they, I'm not sure if they signed off on the inventory as well. I can't recall now whether they signed off on the field inventory as to what we were taking. I just can't recall. But we always had we had 3 or 4 Serb police officers with us when we were doing the search.
And you've said that after this process of what you've just explained, it was taken to the Zagreb field office.
Yes.
Just explain, once it was at the Zagreb field office, is that the stage in which it would have been scanned, or would that have happened at a later stage?
No, that happened when it got to The Hague. The Zagreb field office was just a staging post for us. And it was too much to expect the driver and the investigations team leader to drive all the way from Banja Luka back to, I think it's a 5-hour drive between Banja Luka and Zagreb. So we did a stage point. We had a field office in Zagreb. We decided that we'd stop there overnight. They would have a good night's sleep, and then early the next morning they set off. I think they set off about 6 o'clock in the morning. They took that in the truck that the OTP had in the Zagreb field. The Zagreb field office was an OTP office. It wasn't an ICTY office. It was an office of the prosecutor field office. So they set off early in the morning, and then the rest of the team, we all flew home.
And then once that material arrived in The Hague, what process would then follow?
The evidence unit, I met the truck when it arrived, and the evidence unit met the truck. We unloaded the truck, took everything to the evidence unit, to the vault. We had 2 big vaults in the ICTY. It's a former insurance building. So we were quite lucky that we had 2 massive vaults where I think they held the insurance policies. They were fire resistant, they were flood resistant, et cetera, et cetera. And I think we put it all into there so that we could establish exactly, we had everything that we had seized. Once we'd established that, then the evidence unit, they took over. They signed for it under the chain of custody. There's a special form that they would have signed. And they signed for it, and then the documentation was in their custody. We, as investigators, lawyers, interpreters, et cetera, we had done our job. The evidence unit was now to do their job. The only thing, sorry, that we probably would have done extra is that we probably, but I can't remember in 1997 whether we had electronic or paper metadata, but the evidence unit would have required some metadata to be able to start the process rolling. So, but either way, someone would have put the metadata in as to what the documents were, where they were seized from, dates that they were seized, the authors of the documents, et cetera, et cetera.
And you'd said that the documents were actually driven from Zagreb to The Hague. Was that standard?
No, in some areas we couldn't do that, but we always erred on the side of caution in the OTP. If we thought something could go wrong, we always tried to mitigate the fact that it could go wrong. We just figured that if we flew such large quantities of documentation back, you couldn't fit this in your hand luggage, so it would have had to go into an airline's cargo hold. Or baggage hold, and we just weren't willing to take that risk. So we decided that we would drive it back.
You then mention another example, paragraph 15, which is Banja Luka. I'm not going to ask you to go through that.
Yep.
But
it's exactly the same process.
The same process.
Yeah.
And bearing in mind this, as you've said, a fairly laborious process that was undertaken in missions like this, what would have been the consequences if you hadn't used such procedures?
Well, the documentation could have been questioned in court. I mean, we've used a lot of this documentation. When I retired in August 2018, we had nearly 10 million pages in our evidence unit. And I think conservatively, probably 70 to 75% of that documentation was authored by the parties to the conflict and was either given to us by parties or obtained under search and seizure. So, as I say, we always like to err on the side of caution. And if we thought that a document had the potential to be evidence, then we said, okay, that's got to be treated in a different category to, say, for example, a witness statement. And it has to have all the hallmarks of chain of custody. The fact that we can say in court, if it's challenged, we're able to say in court, no, this is exactly what we did, and these were our procedures. And by having our standard operating procedures and guidelines, it's all uniform, and you can do it.
And by having an unbroken chain of custody,
Yes.
you can verify.
Yes. Yes. And the paper, yeah, and you can verify that by the paperwork. The paperwork follows the documents, yeah.
Now, moving on to, you then mentioned that you were part of the investigation section senior management.
Yes.
What were you required to be aware? Well, let me put it this way: were you required to sign off on mission requests as part of that?
If it was my team that was involved, yes, every mission request had to come across my desk. And if they were going to do search and seizure missions, then yes, that would come across my desk as well. And it was the same with the other commanders. I think we had 3 investigations commanders, and they were the same. And we used to have a morning meeting, so everybody knew exactly what was going on. The chief of investigations and the 3 investigations commanders, we met at 8 o'clock every morning. We'd go through what had happened the day before, what was going to happen today, in the next week, etc., etc. So we basically knew what was happening in everybody's team.
And ordinarily, how much time would go into the preparation of one of these missions?
It depends. I mean, if it was a mission to interview 5 or 6 witnesses, then it would be a mission request. You'd make sure that all the boxes were ticked, that that the field office knew that they were coming, that the vehicles were available, etc., etc. But if it was a search and seizure mission, that was quite a big deal. So, and it wasn't just Northwest Bosnia that we did. I mean, eventually we did the presidency in Sarajevo, we did the Bosnian Croats in Siroki Brijeg, etc., etc. So the search and seizure, they're a different sort of category because, particularly in Bosnia, and to a lesser degree Kosovo, we had to include the military because they were our security. In Kosovo, it wasn't so bad, although we did have liaison with the military, and the British were the driving force in the beginning. So we had a very good working relationship with them from our work in Bosnia. But the Serbs had left Kosovo, so we really didn't get a lot of resistance. The main thing that we wanted from the military was to make sure that when we went in, there weren't unexploded devices and things like that being left in buildings that would be harmful to our staff. So that was the sort of thing, and the military also helped with accommodation and helping us with transport, etc., etc.
And I just want to focus on the advanced planning and what would go into the search and seizure missions. Now, you will have seen from the transcript, or you will have read from the transcripts, that Ms. Pumba, who gave evidence at this trial, initially stated that she had received instructions from the prosecutor orally, later confirmed that she'd received an email instruction, but hadn't made any contemporaneous notes of those instructions. Would that be a normal practice in your view?
No, we would have a mission request, and it would come from the person requesting the mission. It would be in the form of a report, and again, your standard operating procedures make sure that they're uniform. And it would go, in some instances, if it was a search and seizure, it would go to the deputy prosecutor, but it would go through the chief of investigations and the investigations commander. So, for example, if you were doing, like, I was in charge of the investigations where Muslim perpetrators were involved. So we did the Tuzla Corps, the Bosnian army. So the team leader would send it to me, and then I'd make sure that everything was done before I forwarded it onto the deputy prosecutor. In fact, I'd always walk it down to his office and sit in his office and walk him through it. So yeah, and you had to make sure that, you know, all the arrangements are in place, that the military had been fully briefed, that the military were on board with it. Because if you're looking at, say, Tuzla, that's a totally different area of responsibility. That was the American area of responsibility. We had to make sure that the Americans were agreeable to doing the search and seizure, and that they would fully support us, because you can't send a team into that area where they're not secure. And we depended on the military all the time. So there was a multidisciplined effort. So yeah, so there would be a record of everything that was being done. And then you would be kept up to date. And I always kept a diary, so I always write it in my diary what was going on. I've had a meeting with the team leader or whatever. Or there'd be emails coming from the team leader to me saying, look, you know, General so-and-so has agreed. I've had a meeting with him. Here's his email traffic, et cetera, et cetera.
And as the lead investigator in a search and seizure operation, would you have expected Ms. Pumper to have been involved in the planning?
If she's the lead investigator, yes, certainly.
Now, she wasn't involved in the seizure operations on the 8th, 17th, and 22nd. That was another investigator. Now, would that investigator, who is coordinating those searches, I'm assuming the same principle would apply, he would have been involved in those planning discussions?
You would think so, yeah. But there really should have been a paper trail from that lead investigator. First of all, asking for permission for the mission to take place.
Now, you've also read from the transcripts the process that took place within those search operations or seizure operations on the 8th, 17th, and 22nd. You've seen that we've not been provided with a detailed index or itinerary of the material. We'll come to the handover sheets in a moment.
Yes.
But certainly there's no index or inventory of the material that was seized. Would you say that that would be in accordance with, as you understand them, standard operating procedure guidelines?
Our standard operating procedures always said that there had to be an inventory. So yeah, I find it strange that you would go in and take a heap of documents and not know what you've taken.
And
I mean, in the beginning, I mean, we probably, in the SBO's defence, I mean, in the beginning, we used to go in and just vacuum everything up because of the security situation. But after about a year of doing this, we knew in many instances where documents were, et cetera, et cetera. So we were able to then go in and take our time in doing the search. The security arrangements weren't as strict as what they were when we first started it, which was shortly after the conflict.
And obviously a lot of what you're talking about is in a conflict or an immediate post-conflict situation where there was still
Yes.
tension. Here
Yes.
we're dealing with a slightly different situation where there is perhaps
Yes.
more time for planning and preparation.
I would think so, yes.
And you'll also note that on those 3 dates, it was a seizure operation. No search was conducted of those premises. Do you consider that to have been, well, in your opinion, if you were in charge of reviewing this operation, would you not have directed a search?
It depends what you're looking for. I mean, if you know what you're looking for, then you go in, and if it's given to you, then okay, you seize it. If you're not happy with that, or you're hesitant that you've been given all the material, then yeah, I'd carry out a search. I don't know what the size of the premises are, and I don't know how many people were involved or anything like that because I don't have access to that material. But, you know, if you're not happy that you've got all the material, then yeah, you should carry out a search.
And in circumstances where the documents were seized and there was the handover forms that you've seen,
Yes.
no index of inventory, no evidence of sealed evidence bags. Again, in your professional opinion, would this be in accordance with standard operating procedures?
Your Honor, there is
Not
an
really.
objection. I have to note that counsel is testifying for most of the questions put into the witness. So I would request that if such line of questioning needs to be pursued, the counsel request what's the knowledge of the witness.
Are you stating it as a leading question?
It's a leading question, but also is assuming information that the witness did not state that
Well,
he
we
knows.
have to find that out, but please don't lead him. Ask questions that he can answer without you leading him to the answer.
From what you have seen in terms of or what you've read in terms of the transcripts and the declarations, you've already said that from what you can see, there was no inventory.
Yes.
Can you see any evidence of sealed evidence bags and chain of custody, as you would understand it, being adopted in this case?
No, from what I've read and from what I've been provided, I can't see any of that at all.
And again, what would be the consequence of such a practice?
Then you're leaving yourself open to criticism. You're leaving yourself open, more importantly, that when you get to court, which is the whole reason why you're seizing documentation, is when you get to court, the integrity of the document collection is being called into question. Whereas if you follow these guidelines and this chain of custody guidelines, then yeah, you'll still probably be called on it, but you can prove the integrity of the collection.
And in the way in which you understand those procedures to have been adopted in this case, how would you be able to establish, in the absence of chain of custody, that the documents now being relied upon are the documents that were seized?
You're relying on the investigator, I suppose, who sees them, and the integrity of that investigator by saying, yes, they're the documents that I seized.
Now, I want to turn to, which is set out in paragraph 17 and then on to 18 of your report. We can go to paragraph 18. You refer to a manual that was published in 2009. Can you explain what that manual is? And for the benefit of the court, it's at DNH 1023.
Yeah, that manual was a consolidated effort between UNICRE and the UNICTY to capture the best practices of the UNICTY, or shall I say, maybe not the best practices, but the lessons learned from the ICTY. And as a result of the work that we had done over a period of what we've been in existence then, 15 years, the manual was put together of best practices and it was done with the assistance for the international community, not only for other tribunals, but for national jurisdictions, et cetera, et cetera.
And to the best of your knowledge, who worked or contributed to the production of that manual?
I know that in our office, the Chief of Prosecutions had a very high level of work on the manual, but all of us sort of contributed. If we had, the expertise on the investigative side, I think I would have seen some of the chapters that have been put together for the investigative side, particularly in relation to, the standard operating procedures, etc. Plus, we would have supplied a lot of the standard operating procedures to the working group that was working on it, so that they could see actually what the types of guidelines and procedures had been put in place in the ICT, in the OTP.
And was the content of the manual, was the manual widely disseminated amongst the staff of the OTP?
I can't really recall now, but I think we got copies of it. I've certainly got a copy of it. But yeah, I can't recall. I know that we did get quite a few copies in the office.
And do you consider that what's set out in that manual reflects generally what were accepted principles or SOPGs within the OTP at that time?
Yes.
Looking at paragraph 19 of your report, you refer specifically to the section at page 28 of the report on chain of custody.
Yes.
Just again, what is set out there represents the practice that was undertaken by the OTP at that time as recognised standards.
Correct.
And would you say that that is a standard that should be adhered to?
Wherever possible, yes, it should always be adhered to. I mean, you're collecting evidence ultimately for production in court. So you should make sure that every I is dotted and every T is crossed. And by adopting best practices, that's how you can ensure that the integrity of the collection is almost unimpeachable.
And again, on the basis of what you've seen in this case, would you say that the practice adheres to those principles set out in that manual?
From what I've seen and read, no. But there's a lot that I haven't seen. So but it doesn't appear as though chain of custody has been adhered to. And even when I was reading some of the material, even the processing of the documentation, I wondered about, because the batches weren't processed in chronological order. Batch 3, I can't tell when that was processed because it's an entirely different ERN range. But the other ERN ranges, you can see that batch 4 was processed before batch 1, and before batch it was. I've just made a note of it. Can I refer to my note?
Yes, you may. Just refresh your memory.
Thank you, Your Honour. Yes. Yeah, the chronological order should have been batch 1, 4, 2, and 3. That's what the seizures were. But the processing was batch 4, batch 2, batch 1. And to me, that doesn't make any sense either, because maybe with batch 4 and batch 1, you can understand that they may have got it confused. But the second batch was something like 9 days later. And batch 3, as I say, I can't tell when that was processed, whether it was processed as part of all the other batches or not, because it's an entirely different ERN range.
Now, as we're moving on to the analysis of the material, I want to go back to Xylab as we started at the beginning. So, and you start here at paragraph 20 of your report. I just want to ask you, I mean, how does one comply with the practices and procedures relating to authentication of material to be confidential or non-public?
I mean, that's a very difficult question, and I mean that's one of the main reasons why we had it put onto the metadata form, that you could look at it quickly. When you were searching for documents, you could automatically tell straight away from the metadata whether the document was restricted and confidential and chain of custody, or one of the three. And you could tell that straight away just by looking at the metadata form. And that's why we put it on there, so that you could tell straight away. The other way we were able to tell is that in certain instances, in Xylab, you build indexes or indices. And for example, we used to have a Rule 70 index. Now, Rule 70 was to be treated in a totally different way to anything else. It was information that was given to us by states. So we decided to put that into its own separate index so that inadvertently documentation wouldn't be disclosed without the consent of the state or the person who supplied the information. Now, occasionally things slip through, and they always do. But these were the things that we put in place in a best effort not to see them slip through the cracks.
And dealing with material like Rule 70 and other forms of restricted information,
yes.
Would Xylab have the ability to restrict users' access depending upon?
Yes. Yes. Yes, everybody has a certain access, and you may get access to, for example, we had, say, Team 2. So all of Team 2 would have access to anything that related to Team 2. But other documentation that related to, say, Team 9 or to Team 7, they didn't have access to that. And not everybody even had access to Rule 7. You had to have a clearance from various governments before you could have access to Rule 70.
And just again, Rule 70 relates to information provided by another state.
Correct. And could only be used for lead purposes without the consent of that party or that state.
Now, and access to that, in your experience, would be limited to certain users.
Yes.
And to the best of your knowledge, recollection, would Xylab offer the technical possibility to review a document within Xylab and who had accessed it and when?
We could always grant access and deny access. So if somebody had a particular job to do, you could say to the evidence unit, X needs to look at this, so I want them to have access to this index, this index, this index, and this index. And they would be given access, and then when they didn't require that access anymore, you would take that access away from them. So it had that ability to do that. It wasn't a document management system as such. It was more a search engine for us, Xylab. We used CaseMap for our document management. But you could grant access and you could deny access. And if for a specific job, you could give whatever access you wanted to Xylab to an individual. But then you could also take it away from them.
And as a member of the senior management of the investigations team, you would be able to see who had access to that particular document?
Yes, through the evidence unit, yes. I used to regularly review the access rights because sometimes we would have a lot of people, and particularly staff that had departed who still had access rights. So I would regularly review probably every 6 to 9 months and say, no, you can take that person away from there, or that person no longer works in the OTP, they're working in chambers or whatever. So their access can be taken away from all of that.
And would you be able to identify if certain documents had been accessed, downloaded by certain users?
That I can't recall. But I'm fairly certain that you would be able to, because there's there is a, look, I can't be 100% certain on that. I really can't. I'm sorry.
Now, prior to documentation being put into Xylab, as you've said, chain of custody or otherwise, into the evidence unit, what kind of process would be followed? So, for example, as we have in this case, the documents are seized, they're transported to The Hague. they're put into Xylab, what process would be taken before they are actually put into the system?
Well, the metadata should be provided to the evidence unit to enable them. That's a specific form. So the type of document that it is, the description of the document, the author of the document, whether it's chain of custody, whether it's restricted, whether it is confidential. I think we also had a tick box, whether it was a witness statement. There was also a drop-down box as to what investigation it specifically, this particular document referred to. If it was an individual investigation, sometimes they went right across the board. So you couldn't answer that. But yeah, there was a lot of information that you needed to fill out before they would start to process it. And a lot of the boxes we made mandatory, so that if you didn't answer in that box, then the metadata information form couldn't be completed.
Now, in terms of authenticating documents, and if you can turn to paragraph 22 of your report,
Yes.
talk us through how documents would be authenticated in such circumstances.
Well, authenticated, that it would be a document from our office, or
Yes.
authenticated? Yeah. Well, if it's, I mean, I don't know the answer to this, and this is why I put the two scenarios. But if you've seized documentation with the ERN number on it, then that's a very simple way of authenticating that it's one of your documents. And you can go into Xi, search on those particular ERNs, and they'll come up straight away. If they're not ERN, then there are specific searches that you can do within Xi to be able to say, okay, is this a document that we have in our document collection? And you just do keyword searches. And we had a specific unit within the Office of the Prosecutor that could do that type of searching. They also used to do all the searches for our disclosure. And we would give them, or the lawyers would give them the parameters that they wanted searched for example, exculpatory evidence. And they would do the searches, and they were very effective at it.
And staying with paragraph 22, why, in your opinion, is it necessary to check each and every page?
Well, if you're alleging that these documents came from the office, then by only checking every single page, can you get a definitive answer to that? And I mean, it's a time-consuming job, but I think I just added up in my head this afternoon, there's only about 3,000 pages. I mean, we're not talking about a document collection of 100,000 pages, like, you know, the first Krajina Corps in Bosnia. It's 3,000 pages. So, you know, with a team on it, you should be able to knock it over fairly quickly. I would have thought anyway.
You mentioned before about batch 4 and batch 1. So why, again, sticking with paragraph 22, and your answer may well be the same, but why should each and every page of batch 4 and batch 1 have been reviewed or compared?
Well, my understanding was that batch 4 was taken from the media outlet and formed the basis of the documentation for batch 1. So I would want to know that, okay, so every single document that's in batch 1 went to the media outlet, or which ones didn't go to the media outlet. And
having read what Ms. Pumper said in evidence, which you refer to in paragraph 23 of your report, that the analysis was done by way of sampling, sometimes just looking at one witness on the list. I mean, what's your view of taking such an approach?
I don't agree with the sampling approach. I think if you're going to do a job, particularly where people are not going to get the documentation to be able to do an independent assessment, you have to check each and every single name or each and every single document, page of every document that's there, and then make an assessment of that. You know, now for example, with witnesses, if it's a letter that's been written to somebody with an annex of 100 names on it, then I would make sure that every single one of those names were put through the databases, whether it be Xylab, whether it be a witness database, and that you have a classification for that witness. You know, the witness is deceased, the witness refused to cooperate, the witness couldn't be found, the witness has got protective measures from the ICTY, trial case or whatever, so that you know exactly what's happening with each and every single person. From what I could see, that hadn't been done. And I think as an investigator, I think it should be done that way. And again, as I said, and I may be misunderstanding, but there can't be another independent assessment made because people can't see the documentation.
And I think you'd mentioned that difficulty is because the defence has not seen that information, and actually the trial panel to some extent have not been able to see that documentation. That is why the full independent assessment is so necessary. Is that what you're saying?
Well, that's so that you can be 100% confident that what you're saying is correct. And that somebody who doesn't get to see the documentation can have confidence in the spreadsheets that you've put together.
And in evidence, as you've seen from the transcripts of Ms. Pumper, she said that the verification process was not completed. Can you think of any reason why it would have been stopped?
No, I mean, no, I can't give any reason for that. Only she can give that reason. But for, as I say, for 3,000 odd pages, 3,100 pages or whatever it is, it's not a massive job. It's a time-consuming and it's a tedious job, but to my mind, it's a job that needs to be done.
Now, moving on to paragraph 24, you've obviously looked at the analysis of the three operations on 8th, 17th, 22nd. With reference to those delivery notes, so the first two are referred to as delivery notes, in your expert opinion, is that a sufficient basis when seizing material such as this?
Not in my view. You know, absent an inventory, I mean, all that is basically is that, you know, we've taken some documents from you and a signature, but you don't know what documents have been taken. In fact, you don't even know how many pages have been taken. And you don't know what's happened to them, where they've gone or anything like that. It just looks like a receipt to me.
And I appreciate that you've said that you haven't seen everything. But if all we have is those delivery notes, again, in terms of chain of custody, how would you establish that?
And there is an objection, so it calls for speculation.
Overruled, you can answer. Overruled.
That can't be substituted for chain of custody. That is not chain of custody.
Now, I want to take you to paragraph 26. I just want to check that paragraph 26 is not one of those that is... It's not to be mentioned.
Correct. 26 is not to be mentioned.
So it's 26 to 28 that I'm... If I could just...
Mr. Cadman, 27 can be used except for the last sentence.
Well, if I can get you to look at paragraph 27,
Yes?
and just give me 1 second whilst I pull it up. And not straying into the last sentence of 27.
Sure.
So you draw a conclusion that no detailed inventory was provided. Now, going back to what you'd said earlier, where looking at the Priador example, if an
Yes.
inventory hadn't been prepared at that time, could it have been prepared at a later stage and then taken back to the WVA?
Yes. I can't see any reason why it couldn't be.
Would that, in your opinion, have been a sufficient basis for establishing a chain of custody?
Not for establishing a chain of custody. It would have been enough to establish the inventory has been delivered, but the chain of custody needs further development, if I can put it that way. That's not chain of custody just by delivering the inventory.
Mr. Cadman,
Chain,
don't want to interrupt you, but we are at 9:30. Can you tell me approximately how much time you have left?
Well, in light of the parts that I'm not to go through, I probably can finish by 10 o'clock.
Okay, go ahead.
Now, I want to move on now to an item that relates to the leak of the documents themselves, or the security breach, as it's been
Yes.
suggested. Now, in your 25 years of experience at the ICTY, are you aware of any security breach of that magnitude?
Objection, Your Honor. I would like to note which paragraph of the excerpt report the Council is referring to.
Please so indicate, Mr. Cadman.
I'm referring to what the expert has been provided with the transcripts of Ms. Pumper's evidence. These are matters that she referred to. It's also
But we are dealing today with the allowed portion of his report. So answer the question, what paragraph?
It's not set out in his report, but he was provided with the transcripts. He's entitled by the Court of Appeal's decision to comment on Ms. Pumper's evidence to the extent of the investigation. It's not in his report, but we say it falls squarely within what the Court of Appeals has said we can refer to.
Madam Prosecutor.
Your Honor, there is an objection in relation to the fact that the testimony of this witness is permitted in relation to specific paragraphs of the report, clarification to those paragraphs, and explanation on those paragraphs. In any event, there is not even a reference to the specific portion of Ms. Pumper's testimony that counsel is referring to, and I don't believe there is any reference that the counsel can provide.
We can refer to the declaration of the 9th of February, paragraph 7 and 11. I'm more than happy.
Mr. Cadman, we were discussing.
I do apologize.
First of all, what portion specifically of the transcript are you referring to?
Well, we're referring to, and I can identify the reference, but there's certainly reference to these matters in the 9th of February declaration, 7th and 11th. There is also matters that were put to Ms. Pumper, and I will identify the actual reference for Your Honours, when she was asked questions about what steps were taken within the office following the announcement of the security breach. Those are the specific points that I want to put to the witness. But I will identify the transcript references for that.
What you are getting at and want to ask questions about is about what happened in the internal functions of that office
Yes,
during the investigation of the leak.
yes,
And that's all.
yes.
All right, that, your objection will be sustained. That is clearly beyond the scope of the report and the decision of the Court of Appeals, and by any decision we have made. That is not what this witness was called to testify about, and his report mentions nothing about it. So the objection is sustained.
Your Honour's ruling is I'm not allowed to put any questions to Mr. Reid on the actual leak and the matters that Ms. Pomper commented on in relation to what steps were taken, both in terms of an announcement to the staff and security measures that were taken as a result of the leak.
Yes, because that's clearly beyond anything that was notified to the prosecution. It would be unfair to them. They've not had a chance to prepare for it. And your report does not mention it in any way, or I mean, sorry, the witness's report does not mention it in any way, nor does your instruction.
Mr. Reid, earlier when we were discussing the planning for the search and seizure operation, and again, I appreciate it is difficult to give a hypothetical opinion as to the level of planning that would have been required. Let me ask you this. Would it have been appropriate for the planning for a mission such as this, or the 25th of September search and seizure operation, for that to have been planned on the day or a day before the operation was carried out?
Yes, it can be. I mean, from what I've seen, I don't know how the allegations that these documents got into the War Veterans Association, how it came about. I don't know what the length of time before the SPO knew. So I have no idea about that. But if you got it on one day, I would expect that you would be in there the next day to get your documentation back. But again, by having uniformed SPOs or standard operating procedures and guidelines, that's not difficult. It's just, you know, it's you fill it out and you go. So I wouldn't have a problem with expediency there. In fact, I'd criticize if they didn't go in as quickly as they possibly could to get their documentation back.
But you would nonetheless require them, the team, whether you were leading that or overseeing that, for that to be carried out strictly in accordance with the SOPG as you've stated.
Yeah, I mean, that's why you've got them in place, to ensure that there's uniformity right across the board, and that, you know, the search that's done on the, or the seizure that's done on the 8th is done exactly the same way on the 9th, is the same day on the 17th, and et cetera, so that they're all uniform.
And you'd also mentioned earlier, when you were carrying out some of the operations in Priero and Banja Luka, that it would be, I don't want to put words in your mouth, but it would be advisable to photograph or film such an operation?
Yes, where you can, yes. It's always desirable. I mean, a picture's worth 1,000 words. If you've got a video showing the search procedure and everything going on, then you play the video and it corroborates what you're saying in the witness box.
And what kind of process, when the documents are being seized, and looking at the specific facts of this case as to what had happened in the time leading up to the seizure, would it have been a standard practice for any of those persons present to have been questioned by your officers?
I would probably want a statement taken from the people that are involved with the War Veterans Association as to how they came to be in possession of them, yes. Now, I mean, you know, you'd be, again, you know, you'd be looking at them as probably suspects, so then the rights of that particular person kick in. But absent, you know, I would want them interviewed to find out how they got the documents, et cetera, and a full detailed statement taken.
And would you also have looked at the surrounding area to identify whether there was any CCTV, for example?
Yes, I mean...
Just to highlight, sorry, Mr. Reid, that this is
Sorry.
also outside the scope of the expert report.
Sustained.
Based on the information that you have been provided with and the trial transcripts, the witness declarations, do you consider that the prosecution took all reasonable steps to identify who had actually dropped the material off?
This is
No.
in line with the previous question, and there is a continuous objection.
The objection was sustained.
If I could just take one moment, Your Honour.
Certainly.
Now, Mr. Reid, based on what you have reviewed, the transcripts, the declarations, and I appreciate you haven't seen everything. Let me ask you this. What you haven't seen in terms of some of the documents that you've referred to, would you have expected to have seen those presented in a matter such as this?
There's documentation that I would expect to see in a case like this, yes.
Would you have expected the investigator who carried out the seizures to have given evidence in proceedings such as this?
Objection, Your Honor. The opinion of the expert on this point is irrelevant.
Sustained, it is irrelevant.
Based on everything that you've seen and your assessment with 25 years experience, in your professional opinion, was this operation carried out according to standards that you have set out, SOPG? Do you think that this was an effective investigation in your professional opinion?
Objections. First of all, it's not clear to which operation the Council is referring, and second, is in line with the previous question and is outside the scope of the expert report.
It's not outside the scope of the expert report, but you need to be specific, Mr. Cadman, about which portion, or are you saying the entire thing?
Well, let me start by saying, with reference to the operations of the 8th, the 17th, and the 22nd.
No, I don't believe that they've followed the best practices. I don't believe they've followed what we had in place for standard operating procedures and guidelines at the ICTY. I don't believe that they've been followed.
Well, let me ask you the question on a general level. On your general assessment of this matter, do you believe that this was carried out to proper, effective standards?
Was asked and answered.
Overruled? Answer the question.
No, I don't believe that it was carried out to those standards.
Thank you, Mr. Reid. I don't have any further questions at this time.
Gucati defense have any questions?
No, thank you, Your Honour.
We'll take a break at this time so you have an opportunity to download anything that you need to do. Is a half an hour sufficient?
I would say so, Your Honor,
We will
yes.
reconvene then at 10:15, and we are adjourned.
All rise.
All rise.
Be seated. Ms. Bolici, you have the floor.
Thank you, Your Honor. Good morning, Mr. Reed. I would like to start with the assertion that you make in the last period of paragraph 22nd of your report. That would be on pages DN H0864 to DN H0865. And you state there, for batch 4, it is my opinion that the investigator should have gone through each page of the batch and then compare it to batch 1 and reported on the documents that were common to both batches and those that were not in batch 1, if any. Now, when you filed your report, Mr. Reed, were you aware whether any such comparison had in fact been carried out by an SPO investigator?
Not by an SPO investigator. At that stage, I think when I prepared my report, I'd only read the transcripts, but I didn't have the declarations or the redacted declarations of Ms. Pumper.
And did you read the transcript of Mr. Pumper's testimony carefully when you prepared to file your report?
Yes, I did.
And did you look for information whether a comparison between batch 1 and batch 4 had in fact been carried out by the SPO investigator?
It was unclear to me from the transcripts as to whether that type of analysis had been carried out.
I see. I would like to refer, Mr. Reed, to the transcript of the 18th of October 2021 of these proceedings, and in particular page 893, if you have it in front of you.
Hang on. I don't have the transcripts printed out.
I will ask, if possible, as notified to the court officer, to put this page off screen.
Okay, thank you.
Now, if you look at lines 10 to 15 on this page, Mr. Reed, the investigators was asked, can you tell what kind of documents, what kind of information did you capture in this table? And the answer was, I captured the same information as I captured for batch 1. With the exception here, we have 2 more columns. One is corresponding pages in batch 1 and differences batch 1, batch 4. Later on, she's asked to explain which kind of information is captured in these 2 columns, and she answered, as it is evident here, the composition of where the pages were was different between batch 1 and batch 4, and was rather a tedious work to find the corresponding pages. But we checked. I checked and was able to come up with this column. Can you see the relevant part of the transcript, Mr. Reed?
Yes.
Thank you. And if you look at the following page, which is page 894, lines 19 to 23.
Yes.
So the question to the investigator was, thank you, so just to conclude, so I understand correctly that whenever a page of batch 4 is also included in batch 1, under the column corresponding pages in batch 1, you have indicated which page of batch 1 that particular page corresponds? And the answer is yes. If you look farther
Yes,
down,
correct.
in lines 17 to 23, you will see that the question was to the investigator, am I correct to read this table that whenever a page of batch 4 was not included in batch 1, you have written page not included in the corresponding page column? To which she answers, that is correct. And then the question again was, so beside the instances when you wrote page not included, all the pages of batch 4 could be found also in batch 1? And the answer was, that is correct.
Yes.
Have you read the relevant transcript, Mr. Reed?
Yes, correct.
Okay. Now that I have walked you through the relevant transcripts of the public testimony of Ms. Pumper, can you state whether you understand whether a table was in fact provided and an analysis was carried out comparing the pages of batch 1 and batch 4 page by page?
Yeah, I think I got them in the redacted declarations of Miss Pumper, but mine was all redacted. I just had all black, with the exception of the first column.
Based on the public transcript that I just read you, now that we read it line by line, can you
Yes.
conclude whether from this public transcript you can get information whether a comparison of batches 1 and 4 had been carried out page by page?
That's correct.
You can infer this information from the public transcript that we just read. Is this correct?
That's right.
And you state in your report that your ideal course of action was to make a comparison page by page between batch 1 and batch 4. Is this correct?
Correct, together with the information that was gathered within those documents, yes.
Yeah. And could you explain why you deemed appropriate to note in your report what the SPO investigator should have done, while not noting that this was in fact precisely the course of action that had been carried out by the SPO investigator?
I agree with you now, yes, correct.
So if you agree with me now, does it mean that when you first read the public transcript that was provided to you in order to prepare your report, you did not read it carefully?
I read it carefully, but I've obviously misunderstood what she's been saying. But now that you've highlighted it, I agree with you.
I see. And would you like then to correct the last period of paragraph 27, second of your report, in order to acknowledge that, in fact, there is no comment to be made on this specific task carried out by the SPO investigator?
In paragraph 27, do you say?
22nd, last period.
Yes, I've agreed with you on that, yes.
Thank you, Mr. Reed. Now, when you speak again in paragraph 22nd of ways of authenticating documents.
Yes.
You say there are numerous ways of authenticating documents. And earlier in the course of the examination in chief today, correct me if I'm wrong, you clarified to the counsel for Mr. Haradinaj that you envisaged two different ways to authenticate documents in relation to the present case. If the seized document had year and numbers, then the year and numbers had to be checked against the evidentiary database, correct?
Correct.
If the seized documents did not have year and numbers, then each and every page should be gone through a search, word search, or other searching methods against the evidentiary database. Is this correct?
Correct.
And are you aware, Mr. Reed, whether the documents that were seized by the SPO at the KLA War Veteran Association had or had not year and numbers stamped on them at the time of the search?
No, I was not aware.
And again, did you look for this information in the public transcripts that were provided to you and that you state you read carefully in order to prepare your report?
Yes.
I would like to refer to one out of the many portions of the transcripts that clarify this matter, and in particular to the transcript of the 26th of October 2021, and the pages are 1476 to 1477. In particular, for the court officer, it's page 1477, and the answer is on lines 6 to 7. Now, here, answering to a question from one of the trial panel judges, whether
Yes.
the documents that were seized were stamped with ERN, the investigator answered, line 6, the documents which we have seized, they do not bear an ERN number. Can you see that?
Yes, I can see that.
Did you overlook this information, which appears here and in other portions of the public transcripts when you compiled your report?
No, I'm talking about the 4 batches in my report as to how to authenticate the document, not just batch 4 or batch 1. I'm talking overall, 1 to 4.
And do you have information whether the 4 batches, 1 to 4, at the moment when they were seized, presented ERN numbers stamped on them?
No, I couldn't find any, no.
You couldn't find any information on the public transcripts on this particular aspect?
On the reading of the transcripts, that's why I came up with the 2 scenarios, one with the ERN and one without the ERN, how to authenticate the documentation.
But at the time when you wrote the report, you say you were not aware, you were not informed whether ERNs were present or not present on the seized documents.
Not on all the seized documents, no. I don't believe I was aware.
Okay. And you deemed appropriate to provide your expertise even without having information on factual circumstances that you consider relevant to defining the practices to be followed. Is this correct?
That's why I gave the 2 scenarios, because I was unclear as to whether there were ERNs or not. And that's why I gave the 2 scenarios.
Okay. So if I were to tell you that ERN numbers as results from the public transcripts were not present on the seized documents, we could exclude right away one of the two best practices that you have suggested to authenticate documents. Is this correct?
Yes.
So when you say there are numerous ways of authenticating documents, it all comes out down in the end to comparing page by page with the Zylab database. This is the conclusion that we need to draw from paragraph 22nd of your report, together with the clarifications you provided today.
Yes, page by page. That's the way I do it, yes.
Okay. And I would like to consider, first of all, the case of batch 3. Now,
Yes.
based on the materials that you have reviewed, do you have an idea of what is the nature of the document referred to as batch 3?
I'm sorry, in what way?
You read, you said, or you wrote the public transcript of Ms. Pumper, correct?
Yes.
You read
yes.
the indictment, did you?
Yes.
You read the pretrial brief of the prosecution, the public redacted version, is this correct?
Of the indictment, yes, correct.
Right.
Pre-trial brief, yes, correct.
You read the pretrial brief of the Haradinaj defense, did you?
Yes.
Carefully.
I read it, yes.
Not carefully?
Of course I read it carefully. I wouldn't have done the report if I hadn't have read it carefully.
Okay. How much time did you have to prepare this report, Mr. Reed?
I'm not sure. There was deadlines put upon the report. I think I had to report by the 9th of November, I think, was the last day. And that was when I when I sent the report through. Maybe I sent it through the night before, I can't recall. But I didn't have a long time to prepare the report.
So roughly how many hours did you spend in analyzing the materials that were provided to you, assessing it, and providing your expert opinion?
I couldn't tell you how many hours, but I spent a considerable amount of time.
And you assessed that you had sufficient time to understand what you were talking about or what the material provided to you was?
A bit more time would have been nice. But with the deadline, I met the deadline.
So with more time, you would have read the material more carefully?
I probably would have read the transcripts 3 or 4 times, whereas I didn't have the time to do that.
You couldn't look into the details of what you read?
I looked into the details.
But you missed some?
And yeah, of course I've missed something, yeah. And
Ms.
I've admitted
Bellici.
to you earlier.
Slow down and don't talk over.
Yeah. Now, going back to batch 3, based on the materials that you have reviewed, do you have an idea what kind of document batch 3 is?
I can't recall off the top of my head now. I'd have to go back to some of the redacted declarations of Ms. Pumper to see exactly what it is.
Based on the public transcript, Mr. Reed, which you say you have read, do you have
As
an
I say,
idea?
Off the top of my head now, I can't recall. I know that batch 2, or one of the batches, and I can't remember which one now, were court records. Records from the ICTY. There was a German document from K4 and served requests. But as to which batch it was, I can't recall now.
Okay. So let's go back to this information together, so to refresh your memory on this respect.
Yes.
Now, if you look, for example, at the pretrial brief of the SPO, this would be F00181 red, paragraph 81. Perhaps I can read it without
Sure.
putting it on the screen, unless the court officer has no difficulties with that. Oh, wait. So, paragraph 81 of the public redacted version of the pretrial brief reads that batch 3 is comprised of 2 incomplete copies of an SPO confidential document pertaining to SPO investigation and official proceedings.
Yes.
It includes an analysis of certain available evidence and applicable law. The rest is redacted. It also contains references to potential witnesses.
Yes, yes, I recall that now. It was the JCE and all that. Yes, I recall those documents now. Yes.
Okay. And do you recall whether in the course of the public testimony of the SPO investigator, evidence was provided that this document was an internal work product of the SPO?
Yes, I believe. Yes, I read that. Yes.
Thank you. And do you agree, Mr. Reid, that a draft analysis of applicable law and evidence concerning a criminal case, an internal work product, particularly if not finalized yet, is not something that you would upload in the evidentiary database such as Zylab? Would you agree with that?
Yes, but it would also be found on your in your files. If you do a search right across in your file management system, it would be found in the file management system.
Yeah. So first of all, do you agree that in relation to batch 3, looking into Zylab in order to confirm that batch 3 was an SPO document pertaining to SPO investigation would be completely meaningless, don't you?
Yes, but when you're looking at it as a senior investigator, you would know that that was internal work product.
Exactly. I'm talking about the suggested practice in paragraph 22 of your report. You state, in order to authenticate all the batches, including batch 3, there is no difference there, they are all listed together, you should have looked into Zylab. Now, do you agree that looking into Zylab in order to authenticate a document such as batch 3 would not serve any purpose? It would be completely meaningless. Do you agree with that?
I agree with that, yes.
Would you like to correct?
If it's not.
Yeah. Would you like to correct this part of your report in relation to what we just discussed?
Only in relation to batch 3. I mean, I don't know with relation to the other 3 batches, or other 2 batches, 1 and 2.
Okay, so for batch 3, the suggested method that you proposed is not applicable. Is this correct?
Hold on a moment, Mr. Cadman.
It's not an objection as such, but if Ms. Bellucci can actually let the witness answer before she interrupts and asks another question, it's happening repeatedly. The witness was trying to explain his answer, and Ms. Bellucci fired another question to him.
Thank you.
There may be a slight delay.
Thank you.
Please be aware of that.
Thank you.
I will be mindful.
Please pause, each of you, before you go on to the next question.
I will be mindful, Your Honor. Thank you. So, going back to this point, you suggest in paragraph 22 that the one method to authenticate batch 3 would be to compare it with Zylab. Do you agree today, after having been reminded what batch 3 is, that your suggested method is in fact inapplicable in this case?
In relation to Zylab, yes, but there's numerous other ways that, as I say, that you can authenticate the documents.
Okay.
They were only 2 of the scenarios that I gave. And as I say, if you do a search across the file management system, which at the ICTY, all our searches for exculpatory evidence did that, then you would pick it up there. Or as a senior investigator, you would identify it immediately as being internal work product.
Yeah, and we will move to that in a moment. And I just would like to.
Ms. Bellucci, please, you've interrupted him again.
Sorry, I will be more mindful.
No, it's fine. I've finished my answer. Thank you.
Mr. Reid, you say there are multiple ways of authenticating documents in paragraph 22, But this is the one method that you propose. Did you propose it without having any idea what batch 3 contained?
Was having no idea as to how you file or do your filing systems. I don't know whether you put internal work product into XI. I don't know how you do your filing. In the ICTY, we would not have put it into XI. I agree with you there. Okay. And you've now highlighted to me that you don't do that either. Okay. So yes, searching XILab wouldn't pick the document up.
So based on the ICTY experience as well as the SPO experience, your suggested method would be inapplicable. We can agree on that.
But yes, I agree with you there, but we would have picked it up with the search across our file management system.
Okay. And now you say, but there would be other ways to verify whether batch 3 was an SPO document. Now, do you have any idea whether the SPO investigator, in fact, did identify a document corresponding to batch 3 within the SPO database?
I can't recall now, but I presume she would have. I mean, I would expect her to have.
So I would like... Did you read the testimony of Ms. Pumper in order to look for information whether she had or she had not retrieved a document corresponding to batch 3 in the SPO internal database?
I can't recall now. I can't recall having whether I saw that or not in the transcript. I don't know.
But did you at least look for this information?
I looked for all the types of information that would assist me in compiling my report.
Exactly. And then at a certain point you made an assessment saying what should have been done and was not done. Now, before saying that something was not done, did you check whether the material that was provided to you, in fact, offered you the information that your ideal course of action had, in the specific case, been followed?
I looked at the information. I can't recall now whether it had been done or not. The scenarios that I put forward were things that we would have done in the ICTY to be able to authenticate documents. I was asked generally about the authentication of documents. And that's a way that, or two ways, that you can authenticate documentation.
But you were asked generally how to authenticate documents in relation to this case where you are testifying as an expert witness, didn't you?
True. Yes, that's true.
So before, I'm just trying to understand your process of drafting this report. Before stating what should have been done and was not done, did you even look in the materials that was provided to you for information confirming or denying what had been done or not?
Yes, I looked at all the material that had been supplied to me.
And not for this specific information?
I was looking for information that could assist me as to what had been done or what had not been done, or what the best practices were to be able to find that documentation.
So you looked for information and you must have missed it then while you were reading this transcript. You didn't read them carefully?
I read them very carefully. Okay. Given more time, I probably would have read them a third and a fourth time.
How many hours did you spend on compiling this report?
The question has now been asked and answered.
And not
answered.
Yes, it
has. It's been asked and answered.
We will, I would like to show you, Mr. Reed, transcript from the public testimony of the SPO investigator. And this is the transcript of the 19th of October 2021, and the page is 951. So, if you look, Mr. Reed, to lines from line 21 of page 951 to line 25 of page 952. This is about a page and a half about the comparison that the investigator carried out between the document that she retrieved in the SPO database and batch 3. And I would like to draw your attention in particular to the last two lines of page 952, where the investigator stated, "I've seen in the SPO database different versions of these documents. Was work in progress, so to speak."
Yes.
Had you missed this part
No,
of the
no,
transcript? You were aware?
I remember reading this. I remember the internal work product. I remember that she got it in the electronic format. What I'm trying to say to you is that my assessment was an overall assessment of the documentation and what we would have done to authenticate documentation at the ICTY. That's what I'm trying to say.
Yeah, but your overall assessment also referred specifically also to batch 3.
Yeah, and batch 1 and batch 2 and batch 4.
Yeah.
And overall, what we do.
Okay.
Or what we would have done at the ICTY.
Okay.
Yes.
So you said it should have been found in Xyla, but we agreed this is not a good working method. Then you stated it should have been found somewhere else in the database. You could have carried out a search, a word search, and based on the transcript that I have just highlighted to you, we can agree that this is what had been done. Is this correct?
She got the electronic document, yes. I remember reading that, yes.
Okay. So the authentication of batch 3 corresponds to your ideal course of action, doesn't it?
It's the one way that she could authenticate it, and she has, yes.
It's an effective way.
Yes.
Thank you. Now, moving to batch 1. Based on the materials that you have reviewed, do you have an idea of what is the nature of the documents that were included in batch 1?
In batch 1, I think if I recollect correctly, they were requests from SITF or from the SPO to the War Crimes Prosecutor, together with annexes of witness names, asking specific requests of the War Crimes Prosecutor in Belgrade to find witnesses, etc., etc.
Yeah. Based on your experience as an investigator, is this the kind of material that is part of the record of a criminal investigation?
It'd be part of the administrative record, the request, yes.
Mm-hmm. And the statements of witnesses that were received, for example, as a response to such request, would they be part of the records of the investigation?
Yes.
And based on your experience as an investigator, are records of investigations typically confidential until the time when they are to be disclosed, in public trials?
They're confidential until such time, yes, as you submit to your disclosure obligations. So I suppose the first public knowledge of that would be disclosing the witness statements or declarations, whatever they are, to the defence, and then into the public domain if it was a public trial, yes.
And did you verify if any public trial has started before the Kosovo Specialist Chamber as of September 2020?
No, I don't know.
Your Honour,
Yes.
I do object. Mr. Reid is being asked to comment on matters that he hasn't seen. He has not been able to inspect the documentation. He's only seen the very redacted version. He's being asked to give an opinion on matters that he hasn't seen.
Your Honor, if I may answer to this objection, the witness has seen the materials that the Haradinaj defense has instructed him to see.
The objection's overruled. Go ahead.
So, Mr. Reid, were you aware whether, as of September 2020, was there any public trial before the Kosovo Specialist Chambers?
No, I don't know.
Okay. But if I were to tell you that there was no public trial as of September 2020 before the Kosovo Specialist Chamber, would you agree that records of investigation up to that time would typically be confidential, wouldn't you?
Yes, definitely. Yes.
Okay. And if at a certain point in time the investigative record of a prosecution office were to be entirely confidential, there would be no point in checking every single document against the database to verify whether a specific particular document were confidential, because there were no public documents. Would you agree with that?
It depends. I mean, in certain circumstances, even if we didn't have a trial, we would put documentation into Xylab, which was not classified confidential or restricted. And we may share it with other parties who are conducting trials. For example, you know, if Sweden was conducting a trial and we hadn't started a trial, then if the document wasn't confidential or restricted, we would share it with the Swedish authorities. That's just one example. Mm-hmm. I'm not saying that it's the Swedish, that happened with the Swedes, but I'm just giving an example.
Okay.
So yeah, it depends.
Mm-hmm. And the statement of witnesses, the identities of witnesses on an investigation that had not, on a case that had not gone to trial yet, would you regard those materials as confidential in a typical criminal investigation?
They'd be confidential, but again, I sort of say, we used to have a paragraph, the first paragraph of our witness statements in the latter part of the tribunal. In the first paragraph, it had that the witness was willing to share their witness statement with another law enforcement body of another country.
Yeah.
Now, if we, or they weren't, one or the other. Now, if they agreed to that and we got a request from a national authority for statements relating to crimes occurring in X, then if the witness had agreed to it, we would share it.
Mm-hmm. And that would be a specific waiver to share a document with a specific law enforcement authority. Is this correct?
Yes, correct.
With another prosecution office, with a judicial office, is this correct?
Correct.
So would you agree that before a public proceeding starts, the records of investigation are not public documents that, for example, you would publish on the ICTY OTP website? Would you agree with that?
No, I agree. Of course, I agree with that.
So is it true that when you suggested that every single document had to be checked against the Xylab metadata, you consider perhaps a scenario when a trial had already started and part of the evidence bared a public classification because it had been presented in the courts of criminal trials or disclosed publicly, and some of the evidence presented a confidential classification because it had not been reclassified yet, and not the case when all the records of investigations were still maintained confidential. Is this correct?
I'm not sure. Could you just repeat that again, please?
You might break that up into some parts. It was a very long question and it had multiple parts.
Thank you, Your Honor. The need to check against Zylab, whether a document is public or confidential, is pretty immediate when there is a situation when there are public proceedings already ongoing and confidential investigation still being carried out. In that case, you have multiple classification in the evidentiary database. So for every document, you might need to check what is the classification of that document. Is this correct? Do you agree with that?
Yeah, I agree with what you're saying, but the premise of what my statement was is to search each and every document to ensure that what we've seized is SPO or SITF documentation. That was the premise of what my statement was.
I understand. And in relation to the confidentiality instead, when you said you need to check the metadata to verify whether a document is public or confidential, you had in mind a scenario where the Zylab database would include record of investigation that had been reclassified already as public. Is this correct?
But some of those documents could have been ICTY documents that we supplied to the SPO. So they could have already been used in a public trial. That's what I'm saying. It's the classification of the documentation. And mainly what the premise of my statement there was in relation to witnesses, where you have an attachment, a witness list attached to a request for assistance, then each of the witnesses should have been checked.
This is a different topic.
Okay.
This is a different topic. My question focuses on this point. The need to verify the classification of a document as confidential or public arises when there are multiple classifications of documents, whether there is a possibility that the document is classified as confidential or public. Is this correct?
That's true.
At a point in time when the record of investigation is entirely confidential, the check of each and every page on the metadata to verify the status of that document would be a useless exercise. Would you agree with that?
No, I don't think it is useless. I disagree with you. The reason that I say each page should be checked in the database is to ensure that it's an SPO document. I mean, you're making allegations that all your documents were handed over to the War Veterans Association. What I'm saying is that each page of every document should be checked to say, yes, that's correct. That is an affirmative statement. That is one of our documents, which is confidential.
We'll go to the authenticity, as you call it, in a moment. I was focusing on the confidential classification at the moment.
Yes.
Now, would you agree, as a matter of logic, that if all the records of the investigation at a certain point in time were confidential, there would be no need to verify that the specific page belonging to the record of the investigation was marked as confidential, because all of them were. You would agree with that?
The investigation is confidential, yes.
Thank you. Now, when you filed your report, you have not been provided with any samples of batch 1. Is this correct?
That's correct.
And you were not provided with the Annex 1 to the declaration of the SPO investigator admitted as P90, which is the table describing batch 1. Is this correct?
When I did my report, no, I'd not been given any of the declarations of the investigator.
So, at the time, you had no information about the confidentiality of the markings that appeared on any pages of batch 1. Is this correct?
Of any of the batches. I never had any of that.
Okay. Nor you had any information about the indicia of confidentiality that had been identified by the SPO investigator in providing the detailed description of each and every document?
I had an inkling of what she was doing, but then just as I was reading the transcript, then you would go into private session. So I never ever got any of that information.
Understand.
And that's not a criticism of you going into private session. I fully understand.
Yeah. But you are aware that you have no information at all about which kind of confidential markings do appear or not appear on these pages?
No.
This is correct.
Correct. That's correct.
Yes. I would. I have omitted to complete the questions in relation to the confidentiality character of batch 3 before. And I would like to ask you if we can go one moment back to that topic.
Sure.
We were talking about the draft analysis of evidence, an assessment of the law and the evidence available on a criminal proceedings against certain accused persons. Now,
Yes.
do you agree that if a draft analysis of evidence summarized, described, assessed confidential evidence, confidential witness statement, for example, the draft analysis would bear the same classification as the confidential evidence that it describes or summarizes?
Yes, correct.
Okay. I would like to show to the expert witness the document with the ERN SPOE 002222921 public redacted version.
I think I've got that in paper format. Did you send that to me earlier?
We did, yes.
I printed that out. That's 222291 ending, SPOE.
Yes.
Yeah, I have that printed out in front of me.
I will wait for the court officer to put it on the screen for the benefit of the panel. Now, Mr. Reed, looking at the page in front of you, can you see the SPO logo on the top of the page in the center?
Yes?
And can you see the words confidential on the top right corner?
Yes?
Can you see the words internal work product on the top right corner?
Yes?
And the word confidential on the bottom left corner?
Correct.
Now that's a redacted page
Yes.
of batch 3. And according to your expert opinion, what is the classification of this SPO document, which includes in the heading and footing the word confidential twice and the expression internal work product as well?
It's exactly the same as it would have been at the ICTY. It's a confidential document.
And,
That shouldn't be shared, an internal work product, it shouldn't be shared outside of the office.
and you did not need to look into the SPO Zylab database to come to this conclusion. Is this correct?
No, that's what I said to you a few answers ago when we were discussing batch 3, is that this is one way the investigator probably wouldn't have had to interrogate anything. You just look at it and say, that's internal work product. It's confidential.
So,
That's what I'm saying.
so do you agree that a way to authenticating this document is for a person who knows what this document is to find it in the SPO database, to verify that it's a draft analysis and to confirm that it is an SPO document dealing with SPO investigations and is an internal work product. Is this correct?
You wouldn't have to go through those processes. You would just look at it and say, that's our document.
Indeed.
Correct.
Thank you. Now, Mr. Reed, do you agree that the chain of custody is a way of demonstrating that the materials that have been seized are in fact the materials that are presented as evidence? Would you agree with that?
That are presented in court, yes.
And the proof of authenticity would be the goal, and the chain of custody is the tool to reach this goal. Is this correct?
Correct, yes.
Now, for example, in a case where the accused described the materials prior to the seizure, and this description matched with the seized evidence, that would militate as an additional argument for authenticity. Would you agree with that?
I'm sorry, I don't understand. What?
So, imagine a case where the accused were to describe a certain batch of documents in quite a lot of details, and then that batch of document would be seized. Now,
Yes.
If the description provided by the accused prior to the seizure matched to what the documents in fact were, would these be an argument in favor of authenticity of the documents that are considered?
Well, it depends. It depends if it's admissible or not. What he's saying, the documentation, the chain of custody of the documentation, is taking it from where you seize the documentation. You can prove every minute of every day where that particular document has been. That's the chain of custody, regardless of what the accused says.
Yeah, but let's assume that these assertions are public evidence. The accused describes what he has in his hands. Now then, what is considered as evidence, what is presented later on, matches the description of what the accused describes. Do you agree that this assists in establishing authenticity of what has been in fact taken from the accused?
It would certainly assist, and the chain of custody would then corroborate and bolster that particular evidence that you're trying to present.
Yeah. Now, in a case where the accused showed on camera some of the materials prior to the seizure, and images from the video recordings matched with the seized evidence, that would militate as an additional argument for authenticity, wouldn't it?
I disagree with you.
You disagree?
I disagree with you. I think it's extra evidence that you've got in relation to your case, but you've still got to prove the authenticity of the particular document. The video would just corroborate what you're saying, but you should always, in my view anyway, you should always treat the documentation to the highest level that you can. And if you can do it, then you should.
Absolutely. And the video evidence that would show what the accused had in their hand would corroborate that what was seized later on was in fact what the accused had, if the images matched. Is this correct?
Exactly. And the video should also be treated, when you seize that, as chain of custody.
Yeah. And imagine a case where the evidence shows that there were multiple copies of the same batch of documents, and of these copies, one was seized, and one was subsequently retrieved by a third party. Now, if
Yes.
the two copies were to match with each other, like in the case of batch 1 and batch 4, that
Yes.
would be an additional argument for authenticity, wouldn't it?
It's a great argument for your prosecution case, yes.
Thank you. And in a case where the accused never denied that they possessed and made available to the press copies of the documents that were subsequently seized, but only argued that their course of action was somehow justified, would this position be an additional argument for authenticity? Do you agree with that?
Well, it depends on the admissions they made in relation to the individual documents. I mean, I don't know what that is. But yeah, I mean, the reason for me saying that you should treat the documentation at the highest level, if you're going to lay charges against somebody, your documentation should be squeaky clean.
Absolutely.
And all that sort of evidence that you're putting to me now should also be held to the highest regard. The videotape, the statements of accused, whatever. I mean, that should all
Yeah, absolutely.
be held.
Yeah, I agree. And in staying in in relation to what I asked you, so in a case where the accused never disagreed that in fact they deliver the documents that the prosecutor authorities seized to the prosecution authority, would you consider that this is an argument in favor of authenticity of those documents?
Objection, Your Honour. The rephrasing the same question several times just because Ms. Bellucci is not happy with the answer. It's asked and answered.
He
Overruled,
answered
you
it.
can answer the question.
Look, I think it's one way of proving the authenticity. But I mean, in any investigation, as you probably know, you should be trying to get as much evidence as you possibly can to the highest standard that you can get that evidence.
Absolutely.
And the documentation should be treated, if you can, treat it to the highest degree and put the highest standard on it. If you know that you're going to use that in a criminal trial, then you should try and put chain of custody on it and take it from when you got it to when it just adds weight to your case.
Agreed, and we also agreed that that the chain of custody is a tool for authenticity. It's the goal. It's not the goal. It's the tool. Is it correct? Do you agree with that?
Well, it proves. I mean, you can sit in the witness box and be totally confident that if you're questioned on the authenticity of those documents, you can say that is the document that I seized at that place, and I can prove it. And
Yeah.
you've got the paperwork to prove it.
Yeah. And in a case where pictures of the documents published by the press match with the pages of documents that were seized. Sorry, in a case where the accused never denied that they made available to the press copies of the judgment, and those pictures that were published by the press matched with the seized documents, that would be an additional argument in favor of authenticity. You would agree with that?
It's additional evidence, I mean, that you're getting.
Yeah.
But I mean, the accused could come to court the next day and say, I never said that. Or they weren't the documents they took from my premises. Mm-hmm. And you've got to be able to prove conclusively that that is. And that's why I'm saying the best practices should be employed when you're seizing the documentation, or you're taking a video, or you're seizing the photographs from a media outlet, or whatever, or newspaper columns, whatever it is.
Yeah. And in your report, at no point you assert that based on the materials that you have reviewed, you came to the conclusion that the chain of custody was broken, do you?
As far as I was concerned in my report, there is no chain of custody.
Have you
that I can see.
And have you requested to the council who appointed you all the relevant materials that was disclosed by the SPO to the defense in relation to chain of custody?
No, I've taken the instructions from counsel, and I've looked at the documentation that he has supplied me, or his office has supplied me.
And have you verified at any point in time whether council had available any other documentation concerning chain of custody? Did you ask?
No, because I presumed I would have got it if there was anything there.
So you never asked whether, for example, there was a paper trail that was disclosed to the defense concerning the movement of these documents, did you?
No,
You never asked whether there was documentation that was disclosed to the defense concerning the submission of these documents into evidence?
no, I never got any sort of documentation like that. And as I say, I presumed that had that documentation existed, it would have been supplied to me to assist me with my report.
But it has been not. Is it correct?
I've not got any of that no. Like a paper trail, I've never seen a paper trail of when the documents were seized, whether it be batch 1, 2, or 3, whether there's a paper trail from the Office of the War Veterans Association to when it hits the evidence unit and is processed in their evidence unit, or CEMU, I think you call it.
Okay.
I've not seen any paper trail like that, no.
Okay. And if you wanted to argue, let's say hypothetically, that the chain of custody had been broken, you would need to give a look to this paper trail, wouldn't you?
If there's a paper trail that exists, yes, you'd have to look at the paper trail to say, yes, the chain of custody has been broken, or it's perfect.
Thank you. And I would like to refer to the manual on developed practice that you have attached to your report.
Yes.
Now, I would like to refer in particular to page 5 of the manual, if I can ask the court officer please to put it on screen. Is this page? Page 5, please. I will. That would be the, yes, no, I apologize. I will. So I would like, court officer, please, to move to page DNH 1030. And paragraph 80 of the manual, if this could be put on screen. Now, in this part of the manual you are referring to, there is a reference to the OTP practices on appointing and instructing expert witnesses. And in particular, paragraph 80 reads that internal OTP policies and procedures regarding the handling of experts emphasize that, inter alia, experts should be fully informed regarding the matters at issue. Now, did you consider that this particular guideline that was applied at the ICTY, OTP, did not apply to you in providing your expert opinion in the present case?
No, and I don't go away from what the best practice is there. But my knowledge and having worked with experts is that we always supplied the information to the expert.
So you assume that you were provided with the information that you needed, and when you didn't have such information, you just assumed the information did not exist. Is this a fair conclusion?
Yes, that's what I said just a little while ago. I presume that if the information was there, it would have been supplied to me.
Okay. And when you omitted to note that, for example, the items seized at the KLA World Veteran Association did not present ERN numbers on them, did you consider to have been fully informed when you provided that part of your expertise?
Well, I had that information before me. You pointed that out earlier, then that public transcript of the investigator. So I was supplied with that, but there were no ERNs on that.
You had the information, you didn't elaborate on that, you mean?
I had the information, I just misunderstood what it meant. That I'd been supplied with that information. That was in the public transcripts that I'd been supplied with the investigator.
And when you omitted to note that a comparison between batch 1 and batch 4 had been carried out, were you fully informed about the matter at issue?
Would you fully inform me now by pointing it out in the public transcript? And had I read it more carefully, then I should have picked it up as well. If I'd read it 3 or 4 times, I probably would have picked it up. But I didn't pick it up, for which I apologise. But it was there. So I had been given that information.
So you were fully informed, but you did not elaborate on the information. Is this correct?
Yeah, I suppose that's correct, yes.
And when we look at this manual that you cited as an authority, do you agree that this publication is intended to provide an overview of the working methods developed at the ICTY, and it is not a dissertation on legal requirements for investigation, adjudications, or prosecution of criminal cases?
No, it outlines right across the board, chambers, registry, office of the prosecutor, the best practices as we saw it. And it's meant as a guide to practitioners in international law as to what we saw as being the best practices.
Yeah. And if you look at the index of this manual, you will see that the entire section concerning the investigation, and this is in page DNH 0996, is summarized in about 18 pages, from page 11 to page 29. Do you understand that summarizing working methods for large crimes investigation in no more than 18 pages imposes an indispensable level of generalization and abstraction?
I wouldn't say abstraction, but it is generalization, yes. But they're the key factors that we saw in working best practices.
Yeah.
But I wouldn't say it's an obstruction. It's not meant to be an obstruction. It's supposed to be something that people can use as a tool or not.
Yeah, I meant abstraction, generalization and abstraction.
Oh, sorry, I apologize.
Yeah, my
I misunderstood
pronunciation,
you.
I know, I'm aware of that.
Sorry. I
So-
apologize.
Yeah, so there is an inevitable level of generalization. Is this correct?
If we were to write a manual on best practices of the ICTY or of any tribunal, it would be thousands and thousands and thousands of pages.
And also,
So this is, yes, it's generalization and to be used for assistance.
yeah. And you also agree that it's not even a manual on best practice, it's a manual on developed practice. Like, it just states what was being done. There is no comparison with any other practice. It's a description of what has been done at the ICTY with a fair level of generalization. Is this correct?
It was developed practices that the ICTY, or I believe, worked for the ICTY and worked quite well, I thought.
Yeah. And do you agree that working methods and practices need to be tailored in relation to the specificities of each case, right?
Exactly. Of course they do.
Yeah. And that it would be difficult to summarize in 18 pages guidelines applicable to all cases with a fair level of scientific preciseness.
Yeah, but I think you're overstating the manual. I mean, I think what the basic of the manual is that the Office of the Prosecutor, I can't speak for Chambers or for Registry, but the Office of the Prosecutor had numerous standard operating procedures and guidelines which they used. So it's not so much the manual, it's the guidelines and the special, and we were developing them all the time. I mean, like in Priador, when we went on that mission in Priador, the one thing that we didn't address was the press. And so when we got back, we amended the standard operating procedure to include a press component of it. So yes, you're always changing, and case by case, yes.
But in relation to this one authority that you cite, I think we agree that in 18 pages there is as much as you can say. You cannot be precise. You cannot adapt to every situation. Is this correct?
No, you can't. But in the particular, what I was asked to do in my report, I thought that the documentation that was outlined in the manual could be of assistance as a best practice that we had, or a developed practice, if you like, at the ICTY, and that's why I included it.
And is it correct, Mr. Reid, that you have not cited to any other single authority in your expert report, but the manual on developed practices that we just considered?
Look, there's many manuals that have been written that you could cite to.
But you didn't.
No, I mean, no, because I was asked what the practices were at the ICTY. And since I'd been there since 1994 until 2018, I used my experience.
Yeah. So the standard, the best practices that you are describing are not in general the practices of international criminal tribunals. You are referring to this one particular experience that you are familiar with. Is it correct?
That's correct. But I mean, when I went back to Africa, when I came out of retirement in 2019, and admittedly, it's the mechanism which goes across the former ICTY and the former ICTR, but practices at the ICTR were very much the same as what they were at the ICTY. And that could be explained because in the beginning, we had the same prosecutor. But for a long part of the ICTR, they had a separate prosecutor to the ICTY, but they still used very, very similar work methods that the ICTY were using. If you go to Cambodia, you can see that, practices were adopted there because, staff of the ICTY would go to Cambodia or go to ICTR, so you would take your experience with you. So I think that's a bit of a generalization to say what you're saying, that it was only specific to the ICTY.
What I'm saying is that you cite to one authority, which is a manual developed at the ICTY. Yes. You do not cite to any other authority. So what I'm asking is, what you're referring to is the practice of the ICTY. This is the scope of the references you give. Is this correct?
What I'm citing to is my experience, both as a police officer here in Australia and to my work at the ICTY and then at the Mechanism for International Criminal Tribunals. That's what I'm citing to. And this developed practices manual if you like, corroborate some of the things that I'm saying in relation to chain of custody and the seizure of documents.
Okay. And we agree that besides this manual, you did not consult any other literature or authority in general.
No.
Is this correct?
No, I didn't. No, I didn't.
Thank you. I will just consult with my colleagues. One moment, Your Honor, if possible.
Yes, go ahead.
Your Honor, just to understand, how much time do I have left for today's session?
That depends a little bit. How much longer do you think you'll be?
I have an issue with some documents that were not yet provided to the witness, so that's the the topic that I want to go next. I cannot go, but I could touch another matter if that would be convenient. I was just wondering how long.
Well, we are scheduled until noon. If we were close to being finished with this witness, we would extend on a little bit, but it doesn't look like we're going to be.
No. I will need Friday for sure, and I have a long section that requires disclosing some documents to the accused, to the expert witness, and that's why. But I could cover another part of the course otherwise.
Knowing that, why don't you cover the other part, and then we'll break and we'll be finished for today, and you can download the documents.
Yeah.
Understood, Mr. Cadman?
Yes, I was just going to say that Mr. Reid had previously indicated yesterday that if we need to go a little bit further today, rather than having to sit on Friday, he can, but he's also available on Friday as well.
Yes, I appreciate that, and I appreciate that, Mr. Reid, but it sounds like we're going to be beyond that. So go ahead, Ms. Bolici.
Yeah. One moment. I would like to show to the witness. I would like to show to the witness a video, and with the assistance. Yeah. Yeah. And that is the video with the era number 10472901.
Ms. Bolici, is this a public document?
It's a public document retrieved online on the website of the Humanitarian Law Center.
Okay. Mr. Cadman, sorry.
I would just ask the prosecutor to explain what is the relevance of some of these matters that are going to be put to the witness.
You should state your case about this so the witness knows where you're going.
Yeah.
Before Ms. Bolici continues, I also note that there were some additional items that were put into the presentation queue that we only picked up earlier that deals with IC2I judgments, again, to explain the relevance of those.
Well, the timing for the prosecution to disclose his presentation queue is at the end of the examination in chief. So that's the moment when the presentation queue was disclosed. And
it wasn't a criticism of late.
Okay.
It was a question of relevance.
yes.
Go ahead, Ms. Bolici.
Thank you.
Please state your case.
Yeah. witness provided, I believe, an interview about some of the difficulties he had with investigating Kosovo cases. And in order to put in context the best practices that he is highlighting as applicable to this case, I would like him to confirm these contextual circumstances concerning Kosovo cases.
All right. Go ahead.
I would like to play for Mr. Reed the portion of the video that goes from minute 6:55 to 7:29.
Witness intimidation in the trials for Kosovo, I've really never seen anything like it before. I was a policeman for 20 years and I've worked here for 23 years and I have never seen the intimidation like it. It was really quite frightening. And I'm not linking that to any individuals or any organisation, but just the fear that was engendered in the society. I've not seen any, even in organised crime, I've never seen anything like it.
Thank you. And is this an interview that you have provided, Mr. Reed?
Yeah, I believe that it was an interview, I think it was with Mirko Claren, I think. Yes. Yeah, I remember the interview, yes.
Mr. Cadman had a comment.
Again, relevance to these proceedings, Your Honour.
The relevance?
The prosecutor is dealing with matters that are historic. I'm at a loss to understand how they're relevant to these proceedings.
You're going to have to state your case with a little more clarity as to why we're going into this. You didn't say that.
Your Honor, this is a case about witness intimidation. It's a case about witness intimidation in Kosovo and obstruction of justice. Mr. Reed has experience about Kosovo cases and witness intimidation in Kosovo cases. I would like to receive the expert testimony about this particular topic.
Mr. Cadman?
And I maintain my objection that that is not what Mr. Haradinaj is on trial for. They can put matters that are relevant to these proceedings. We have, throughout these proceedings, been prevented from bringing in matters that fall outside the scope of the indictment. These are highly irrelevant matters.
If I may
should
add,
not be allowed, Your Honour.
Sorry.
I've heard enough. Thank you. I'm going to consult from...
Yes.
The question is relevant. Witness intimidation is central in this case. It has something to do with this case, and it will be, the question will be allowed, so go ahead.
Thank you, Your Honor. So, Mr. Reed, is this video that I've just played to you, is it an interview that you have provided about your experience in Kosovo cases?
Yeah, it was a longer interview than that and touched on a lot of other subjects. But yes, that's part of it was relating to Kosovo.
And are you speaking in the interview, in this excerpt that I played, about your experience in investigating war crime cases against members of the KLA?
Look, I never... As an investigations leader, at that particular time, I think I was the chief of operations, and my sole part of my work was the apprehension of outstanding fugitives. But I worked very, very closely with the trial teams, and particularly the trial teams on Kosovo, and I had a very close understanding of what they were going through in their trials. And I don't take a word back of what I just said.
So you stand by your assertion that you've never seen something like witness intimidation in Kosovo, not even in organized crime cases?
It's very underground. It's always there. But yeah, I mean, you can speak to a witness one day and the witness just, I mean, I know in one particular case, the witness came to The Hague and preferred to be charged with contempt of court than give evidence.
Yeah. And you say that that it was quite frightening, that you have never seen anything like that, and there is a fear that was generated in the society. Can you elaborate on that?
Yeah, I mean, it's as if you're a traitor to the cause, and yeah, it was always the undertone. And I mean, you can speak with any of the trial attorneys that worked on the cases, or the investigators who worked on the cases, and they would go and speak to a witness one day, and they would go back another day, and the witness had either gone out of the country, or they refused to be interviewed any further.
Yeah.
Now, as I said in the interview, I'm not pointing the finger at any one individual or organisation, but it was just an undercurrent that was there.
Yeah. And when you say it is like if you are a traitor to the cause, can you elaborate on that? So a witness, somebody who cooperates with investigation, prosecution authorities, is regarded as a traitor. Is this the case?
In some instances, that was the way they were treated, yes.
That would be isolated?
Look, I can't give you any specific examples. The specific example I gave you was that a particular witness came to the Hague, was put in the witness box. When asked to answer the questions, he refused. The judge, presiding judge, then told him he would be charged with contempt of court, and he preferred to be charged with contempt of court and imprisoned rather than give evidence against individuals. Now, again, I'm not making any assertions against any of the accused in those particular trials or anything there. But there's something there when a witness would rather go to jail for contempt of court than give evidence.
Yeah. And are you familiar with the case that was tried at the ICTY against Gucati&Haradinaj?
Yes.
And do you recall what was the experience of witness intimidation in that case?
Hold on. Mr. Cadman?
Again, objection to this entire line of questioning. It's completely inappropriate. They have no relevance to these proceedings, has no relevance to these accused.
I'm sorry, overruled. You can ask the question. You may answer the question.
Did you get my question, Mr. Reid?
I'm sorry, could you repeat it again,
Yeah.
please?
Do you have a fair recollection whether the Haradinaj case at the ICTY was affected by an issue of witness intimidation?
Yeah, it was a very, very difficult trial. Yeah, I mean, that's pretty much all I can say is that, you know, witnesses who had been interviewed just refused to give evidence.
Yeah. And I would like to read a small excerpt from the Haradinaj trial judgment. It's IT 0484T of 3 April 2008, and it's paragraph 6. And it reads, the trial chamber encountered significant difficulties in securing the testimony of a large number of witnesses. Many witnesses cited fear as a prominent reason for not wishing to appear before the trial chamber to give evidence. The trial chamber gained a strong impression that the trial was being held in an atmosphere where witnesses felt unsafe. This was due to a number of factors specific to Kosovo. For example, Kosovo small communities and tight family and community networks, which made guaranteeing anonymity difficult. Does this description correspond to your experience in dealing with witnesses in cases against KLA members?
Mr. Cadman?
Maintain the objection. I will continue to maintain the objection through this entire line of questioning. Again, it is completely irrelevant to these proceedings. The defence has been prevented from putting historical matters. These are historical matters. The prosecution should not be permitted to continue with this line of questioning. It is inappropriate, and I'm at a loss to understand how the trial panel can allow this to continue.
Objection is overruled.
Mr. Reid, the tight, small communities in Kosovo, have you experienced the difficulties in securing witness evidence in relation to the difficulties of maintaining the anonymity of the cooperation of a witness with the OTP of the ICTY?
Yes. Yes, and what the trial chamber outlined in that judgment is, yeah, that's correct.
Yeah. And would you agree that in this climate of witness intimidation, if somebody who cooperated with the prosecution authorities were to be addressed as a traitor or a collaborator or a spy, this would produce an intimidating effect on witnesses? Do you agree with that?
Yes.
And would you agree that if in the course of investigations, somebody were to announce that all the persons who cooperated with the prosecution authorities were now known and that nobody was unknown and they would be called spies or traitors or collaborators, this could generate an intimidating effect on witnesses? Do you agree with that?
On witnesses and the investigation generally, yes. But I was never asked to comment on that in the report.
Yeah. And would a witness who cooperated with the ICTY OTP in Kosovo cases against KLA members normally require that his identity be maintained confidential, at least until the trial proceedings started?
Until the disclosure process started, yes.
Yeah.
And many of them didn't even understand why we had to give the excuse me, why we had to give their name over to the defence.
Yeah. And
Just a second, Mr. Cadman.
Your Honour, I would just ask for reference to Rule 143.3, which deals with the scope of cross-examination. These are matters that fall outside of that. If Your Honours are going to allow Ms. Bellici to deal with historical matters that we don't think are necessary or relevant, it certainly falls outside of the scope of cross-examination. It doesn't deal with any matter that the expert has done with in direct examination, and it doesn't deal with any matter as to his credibility.
Your Honour.
And if you read the balance of paragraph 3, you will see that the cross-examining party the witness may be examined on the subject matter of the case of the cross-examining party, and that is what the prosecution is doing. Your objection is overruled.
Yeah. And Mr. Reid, and do you agree that in your experience in investigating cases against KLA member, maintaining the anonymity of those who cooperated with the prosecution authorities, at least up to the commencement of the trial, was crucial to the success of the investigation and prosecution? Is this correct?
Of the investigation, yes, but not so much the prosecution.
Yeah. And when you state that there were witnesses who requested protective measures in relation to their testimony in Kosovo cases against KLA members. In your experience, is the request for protective measures something that occurs once an indictment is filed and confirmed? Is this correct?
The protective measures at the ICTY, if I remember correctly, were allowed. We had to make an application to the trial chamber.
Mr. Cadman.
Protective measures.
There's no evidence here that the witnesses that the prosecution purports to rely on in this matter are subject to any protective measures. If I fail to see the relevance, I will continue to object.
Objections overruled. Go ahead.
And Mr. Reid, even before protective measures were granted in the course of a criminal trial, would you regard the statements, the identity of those who cooperated with the OTP of the ICTY as confidential statements provided by witnesses whose identity had to be maintained confidential for security reasons?
I mean, that was right across the board. That was just an operating procedure that we had with all witnesses, regardless of their ethnicity. But yeah, so the confidentiality at the investigative stage remained. But then it went out of our control once the investigative stage had concluded, the indictment had been confirmed, and the prosecution and the trial stage, if I can put it that way, commenced.
Okay. And the very last question on this topic, you say that this fear was something that was widespread within Kosovo society. And would you agree that individuals, witnesses in general, would fear for their safety, their personal safety, the safety of their family, regardless of being the subject of a specific directed threat, but in general, in relation to how witnesses against KLA members were regarded in the Kosovo society?
I mean, it depends on the individual witnesses. And I can't really answer that sort of general question, because even for non-Kosovo witnesses, some witnesses have fears that we needed to address. So it's a fairly general question, but as I said in the interview, Kosovo just seemed to be different.
Thank you, Mr. Reid. Your Honor, my next topic would require the disclosure of materials. I would rather move it to Friday, if possible.
All right. Mr. Reid, we will adjourn today and have you back at 8 o'clock on Friday, same place, same time. And we appreciate your being with us today. Anything else from the parties?
No, Your Honor, thank you.
Okay. We are adjourned.
All rise.
Wait.